Good morning, Chair. I'm Paul Farlam. I appear, unfortunately, alone for the SABC, the fourth respondent, and I'm instructed by ENS.
Thank you. Anyone for the Commission?
Good morning, Chair. It's Simpiwe Gumede on behalf of the Commission. We're here on a watching brief.
Thank you, Mr. Gumede. Let's start with, I think we'll have to start with you, Mr. Trengove, and the affidavit filed by Multichoice in relation to the SABC's answer. Let's start there.
Chair, my learned friend, Mr. Cockrell, will make our submissions on that issue.
Thank you. Mr. Cockrell.
Thank you, Chair. Morning, Chair, morning, members of the Tribunal. Chair, you've allocated 5 minutes for us to move this application, and I hope to take less than that. You'll know, Chair, that the SABC is a respondent in this matter. It's the fourth respondent. It filed an answering affidavit, which, broadly speaking, supports the applicants. The applicant then, in its replying affidavit, quoted heavily from the SABC's answering affidavit in order to bolster its case. And indeed, when the applicant prepared its heads of argument, it also relied heavily on the SABC's answering affidavit. Chair, all of that is unfair to my client, which is also a respondent in this matter. And it's the unfairness to my client which forms the theme through the various judgments which we refer to in our heads of argument, Chair. Chair, I don't have the time to take you to those authorities. I don't intend to do so. But you'll know that there is now a line of authority beginning in the Labour Appeal Court and going through a full court, which indicates that it's unfair on an opposing respondent where a supporting respondent gangs up, in effect, against the opposing respondent. Chair, may I say the judgment of the Labour Appeal Court, which started this, ACL Geomatics, it was a court that included ultimately someone who became the president of the Competition Appeal Court, that's Judge Davis. So that's the line of authority, Chair, and that's the line that we rely on. And so the fundamental unfairness to Multichoice is this: if I can use the wording of ACL Geomatics, what has happened is that the applicant eMedia and the fourth respondent SABC have in effect ganged up on Multichoice. Now, Chair, the unfairness to Multichoice is that in the ordinary course, it has no right to file an affidavit that responds to what the SABC has said, even though the SABC is, broadly speaking, supporting the relief claimed by the applicant. So, Chair, given that unfairness, the dilemma for Multichoice is this: how is that unfairness to be removed? And in broad terms, Multichoice asks this tribunal to do one of two things in order to remove the unfairness. The first would be to rule that eMedia may not rely on the SABC's answering affidavit in relation to issues that were either not canvassed in the founding affidavit or that seek to expand the relief sought by eMedia. In other words, Chair, the unfairness would disappear if this tribunal were to say, not that the SABC affidavit doesn't serve before it, which is what my learned friend seems to suggest in his heads of argument. All we ask for is a ruling that when you ask in due course whether eMedia has made out a case for the relief it seeks, you do not do so by having regard to the SABC's affidavit to the extent that the SABC's affidavit either extends the relief sought by eMedia or deals with issues that were not covered in the founding affidavit. Now, Chair, if you were to make such a ruling, then there would be no need for our conditional affidavit to be admitted into evidence. But, Chair, if you were against us in that regard, if you were to say, no, the tribunal is minded to have regard to the SABC's affidavit when asking itself whether eMedia has made out a case, in that event, my client asked for leave to file its conditional affidavit that is offered in response to what the SABC has said. Now, Chair, that alternative relief arises because we have no right to file a second affidavit. My client accepts that. So it would require your leave to do so, and that is the application that serves before you if you were not minded to give a ruling saying that the tribunal will not have regard to the SABC's affidavit for the various instances that I've referred to. Now, Chair, that application for leave to file the conditional affidavit is not opposed by eMedia. And indeed, eMedia doesn't say that it would want to file a further affidavit in response to my client's conditional affidavit. But it is opposed by the SABC. And the only basis for the SABC's opposition is the SABC says, well, it was filed very late. It was filed on the 23rd of December. But Chair, with respect to the SABC, the one thing they don't say is that there is any prejudice to them caused by the lateness of the filing. The SABC doesn't say that it would want to file a further affidavit in response to our conditional affidavit. That's the one thing they don't say, Chair. If they wanted to file a further affidavit, then their remedy would have been to ask for a postponement of a day, 2 days, who knows how long, in order to respond to that, and they haven't asked for that. So with respect, Chair, our learned friends are critical of us for the lateness of the filing of that affidavit, but there's no prejudice that they rely on. And Chair, with respect, the contradiction in the SABC's approach is this. The SAB says to this tribunal, you must have regard to the SABC's affidavit, even where it is supportive of the immediate relief, and even where it addresses issues that were not set out in the founding affidavit. But having adopted that approach, it then says that this tribunal should not allow my client an opportunity to respond to that affidavit if the tribunal is minded to have regard to it. Now, with respect, Chair, the SABC can't have it both ways. It can't say that is the purpose of its affidavit and that you must have regard to it, but nevertheless, you would tie Multichoice's hand behind their back and not afford them an opportunity to respond to it. So our respectful submission, Chair, I'm going to end my argument now. Our respectful submission is we ask you in the first instance for a ruling that the tribunal will not have regard to the SABC's affidavit for the purposes that I've addressed. And if you are not minded to give such a ruling, then we would ask for leave that our conditional affidavit be admitted into evidence. Chair, those are our submissions. The detail is all set out in our heads of argument. We stand by the detail in the heads, but I believe I've either exhausted my 5 minutes or I'm very close to doing so. Thank you, Chair.
Thank you, Mr. Cockrell. Mr. Farlam?
Thank you, Chair. So Multichoice, as you heard, has a two-pronged argument. First, it submits that you should not have regard to the SABC's affidavit for purposes of deciding this matter. And then alternatively, they want to admit their affidavit. Now, as regards the first, we submit that is entirely untenable. We've set out in our heads of argument the test that applies for interim relief. That test would involve looking at our affidavit. And what my learned friend doesn't highlight is that the case law that he's referring to were all applications to strike out an affidavit on the basis that it was impermissible for the respondent to do what they did. And the parties applied to strike out the affidavit because they would have known that if the affidavit is there, obviously regard must be had to it. They have chosen not to strike it out. And of course, sometimes they rely on our affidavits. There are various parts in their heads of argument where they rely on affidavits. And our position, as I'll submit later, is much more nuanced than both sides appear to appreciate, in that we both agree and disagree. And we're not expanding the relief. I must emphasize this. We are expressing a cautionary word about the relief because we fear that it could be problematic, and I'll explain that later. But as my learned friend referred to a line of authorities for which he seems partly responsible in the courts, but there, in fact, there are two lines of authorities, and that's quite nicely set out in the judgment of Potgieter J in the Eastern Cape in the Oordendal case, because there he mentions there's judgment resilient properties, there's judgment democratic alliance, there's judgment public protector, Magidiwana, and then importantly a judgment of Justice Dlodlo, as he then was before he was elevated to the Supreme Court of Appeal in Clarisons in the Western Cape High Court, where a respondent filed an affidavit that was very supportive of the applicant's case, and there was an application for striking out, and it was not allowed. And importantly, also, what one needs to appreciate is that line of cases is where the respondent is seeking relief that the applicant is seeking. We're not seeking relief. What we are trying to do is we are trying to make submissions which will inform the decision of the tribunal. The tribunal, as we've pointed out, has to make a decision in the public interest, having regard to public things. We are the national public broadcaster. We can make informed submissions in relation to the market. We can informed submissions in relation to harm, in relation to customer harm. Clearly, those submissions must be allowed to be taken into account. And I might just add that to some extent, that the debate is a little artificial, because there's not really that much in our affidavit that has not already been canvassed in the founding papers, because of the fact that they quoted our statements repeatedly, etc. So we submit that in the first instance, they haven't applied to strike out our affidavit. The affidavit is before the tribunal. In accordance with the test, it must be taken into account. And it's important, if the tribunal is going to discharge its duty and give a reasonable and just argument taking into account public interest, that it be included. And as I say, there is a significant line of authority that allows that. This is not the case where a respondent is trying to argue for an applicant. And if one looks at, for example, the facts of the Gold Star case, which my learned friend then they refer to in their heads of argument, there the respondent deposed to an affidavit confirming the contents of the founding and replying affidavits and did nothing but support. Clearly, that's not the case. So we're in a quite different world. The real question then is, well, what do you do about Multichoice's further affidavit? And I readily acknowledge the point that in the normal course, you might be able to say to Multichoice, you don't have a right, but if you'd like to put more facts before the court, the tribunal, yes, you may do so. But in this case, there's quite a distinguishing feature. I think people inevitably refer to the sort of thing as the elephant in the room, is why were they so late? What was the explanation for that? And not only they don't mention that at all. So you have no idea for why, and we've set out in our affidavit with a table the extreme lateness and the fact it was contrary to a directive. And contrary to what my learned friend has submitted, we do refer to prejudice. It pages 62 and 63 of the paginated record for the further affidavit. We point out, and I'll just read out a couple of the sentences. Multichoice would have known, this is paragraph 26, Multichoice would have known that by effectively waiting until Christmas Eve to file its further affidavit, the SABC would have little or no opportunity to respond substantively thereto prior to the hearing date. It would also know that e-media, which as of right would be able to reply, would similarly be unable to deliver a supplementary reply without losing its hearing date. There's no answer to say we can address them in argument insofar as they're referring to facts. Clearly, we should be allowed to respond to those facts. Then at 27, I'm informed it was apparent from the pre-hearing conference that e-media's main concern is not to have the hearing delayed. As the SABC is not itself seeking any relief and is also not the main focus of the application, it would not behoove it to seek to delay the proceedings in order to address the allegations in the further affidavit with the relevant staff at the SABC and its expert competition economist who advised on the allegations that informed the SABC's complaint and thus to its answering affidavit in this matter. The SABC is thus not able at this time to respond in the necessary details to allegations such as the suggestion that soap operas could be swapped for premium sports events without prejudice to the SABC, and can merely record the allegation is fundamentally wrong. It would, however, have been a different matter entirely had Multichoice informed e-media and the SABC in mid-November 2023 that it was desirous of filing an affidavit dealing with SABC's answering affidavit. Contrary to what Multichoice has contended in its further affidavit, the real question is therefore whether Multichoice should be given leave to file its further affidavit by way of an application and affidavit delivered without warning on the afternoon of Saturday, 23 December, in the further circumstances outlined above. Now, we submit that's the thing. So we do contend for prejudice. And what they're effectively trying to do is by filing at the time they did, what they're saying is, either ignore our affidavit, make a ruling that you must ignore the affidavit, or allow us to neutralize the affidavit in a way that does not allow the SABC to respond. And if they're going to be allowed to file a further affidavit, it must necessarily follow that they're saying, well, the SABC is somehow advancing a case and we must be allowed to respond to that. So we submit that is the prejudice. If I may interrupt, but we're not seeking relief in this case. But what is important is, as the tribunal knows, we have a pending complaint. We have set out various things in relation to market definition, abuse of dominance, etc. And what's important, obviously, for us is not only that the harm is not exacerbated, which is what we've set out in our affidavit, but also that there's not a ruling that's problematic, and that this tribunal has the full facts before it. We submit this was not able to be done by virtue of the timing. So it's because Multichoice waited so long and then didn't even have the courtesy to explain why they took so long, in fact, even to let us know they were going to file. We only discovered on the 27th of December. We submit that's a different factor. And so fairness, justice, interest of justice then mean this is a different situation from the usual case. And effectively, Multichoice have forfeited the opportunity to file an affidavit by their conduct and then by the fact that they failed to provide a proper explanation. Thank you, Chair.
Thank you, Mr. Folham. Should we, if we allow the further affidavit by Multichoice to be admitted, are you also then asking us to admit your response that you filed?
Yes, the difficulty.
You did file a response. You did
yes,
file a
yes,
response
no, we
in
did.
terms of the timetable.
No, we did. The difficulty with our response is that we're not really able to deal substantively. So, for example, one of the allegations is we are always late, that we basically are a cause of our own misfortune because we never come to the party in time. Another allegation then is, well, look at things, substitutability, etc. So, yes, if the tribunal is minded to admit it, they can admit our affidavit. But our affidavit, unfortunately, does not really take the substantive issues further. It really just deals with why they haven't behaved very well.
Okay, thank you. Mr. Du Plessis, any submissions from your side on this issue?
Thank you, Chair. I mean, we can be very, very short. We simply submit that the SABC is answering affidavit. Obviously, has to be considered for the reasons that Mr. Folham has given, and is admitted for the proper determination and the full determination of not just the competition harm in this matter, but also critically the constitutional harm in this case, in which we will be speaking about a little further. But it is correct that we are not opposing Multichoice's further affidavit, and the fight around its further admission is between Multichoice and SABC.
Thanks. Let me check if the panel has questions on this issue. Ms. Mzwai?
Yes, thank you, Chair. The question is to Mr. Folham as to the issue of prejudice and what prejudice Multichoice would suffer in the context of the answer that it has provided to the conditional affidavit.
So I'm not fully in terms of the prejudice that Multichoice would suffer, or the SABC would suffer. So I didn't.
The SABC would suffer. The SABC would suffer.
Yes. Yeah. I mean, the only thing is that what the reason, and I don't want to make too much of this because eMedia is not opposing. We're not really, actively bring this application. But what we submit is that what we find unfair is that there are allegations made. They've basically dealt with a number of our issues. Any sort of sensitive issue, Multichoice has tried to deal with in their affidavits, and they've done so at a time which did not allow the SABC to respond. Now, that's just the point. What as I read out from the things, we would like to have consulted with the SABC, and we had a competition economist who advised on the market definition and the other factors. We weren't able to respond to that. There were various factual allegations, as I say, that we weren't able to respond to. Now, so there's simply this. There's that prejudice. On the other hand, I do acknowledge that there's prejudice Multichoice, but as I say, the question is, well, can they really complain if they've waited so long?
Okay, right. Thank you.
Thank you. Professor Vilakazi? Okay, thanks. The panel will consider this matter, so we'll break for that. I think let's return then at 11. We'll consider the matter and give a ruling, and we can come back at 11 o'clock. Thank you.
Chair, before you adjourn, Multichoice is moving the application, and the timetable did provide for a very brief reply.
Yes, you, Mr. Cockrell, you may reply shortly.
It's going to be less than a minute, Chair. Chair, my learned friend, Mr. Folham, very fairly, in response to the question from the tribunal a minute ago, said that there would be prejudice to Multichoice if his client's affidavit were to be had regard to by the tribunal, but my client's conditional affidavit were not admitted. With respect, that really should be the end of the case. It's a fair concession, and we're grateful to him for making it. The prejudice to my client is it is then left stranded in a world where the SABC affidavit serves before the tribunal. E-media relies on that affidavit to support its case. And remarkably, in that world, my client is not afforded an opportunity to respond to what the SABC has said. With respect, Chair, the tribunal would not tolerate such a gross unfairness. And so we would continue to ask either for the ruling, or if you are not minded to do so, we would continue to ask that my client be granted leave to file its conditional affidavit. And my learned friend hasn't pointed to any prejudice that the SABC would suffer in that world. He was asked the question directly. So with respect, Chair, we would continue to ask for the relief. Thank you, Chair.
Thanks. We'll come back at 11 then. Thank you. Check if everyone's back. Mr. Duplessis. I don't see Mr. Duplessis yet. Okay, we're all back. The panel has considered the submissions of the parties, and we have decided to admit the conditional affidavit filed by Multichoice in response to the SABC's answer. We can then move to the main matter. Mr. Duplessis.
Thank you. Thank you very much, Chair.
Just to remind you of your time allocation that we've given you, 1 hour and 15 minutes.
Yes, indeed. Thank you, Chair. As you know, we're before this tribunal for urgent interim relief. As I've said, I will speak on certain aspects and Mr. Marriott on others. Mr. Marriott is going to show you that eMedia is the only party that meaningfully competes with Multichoice, and he will explain why the open view restriction is an abuse of Multichoice's dominance under the Act, and why the balance of convenience overwhelmingly favours eMedia in relation to competition harm. And he's going to show you convincingly as well that eMedia is not free riding as Multichoice has shrilly contended. It is, alongside the SABC, seeking to prevent abuse of dominance by Multichoice in a manner that concerns particularly consumer welfare. He's also going to show you that eMedia's case is supported by a trilogy of comparative decisions that highlight that such abuse, where a restriction is inserted by a rights holder, is struck down by other competition authorities in other parts of the world. And so I'm going to reserve for him that competition and economic analysis, and you might, with respect, reserve your questions for him in relation to those aspects of the case. The intrigues of market definition and competition dynamics and the definitions under the provisions of the Act applicable are his preserve. That said, my task is to precede him and to explain that it's not just any interim relief that we're seeking. It's the context in which we seek that relief is vital. And there are two contextual points that fall to me to make in this regard. The first is the Constitution's resonating impact on the tribunal's exercise of power and the relief that is being sought by eMedia. And the second contextual point for me to deal with are the unavailing and, with respect, dismissive responses by Multichoice to the constitutional context and also the constitutional harm in this case. And they do so in two ways. The first is that Multichoice ignores the manner in which those impacts frame the relief that is being sought under Section 49 of the Act. And secondly, it ignores the obligation upon you as the members of the tribunal to do your duty under the Constitution to prevent such constitutional harm. So as I say, I intend to spend around 30 minutes or so underlining the constitutional context and that constitutional harm. And those aspects which I touch on under the Constitution, of course, relate directly to the consumer welfare point that Mr. Marriott will elaborate upon. But the Constitution gives particular shine and salience to the issue of consumer welfare in this case, perhaps like few other cases with respect. And the powers, therefore, and indeed the duties upon this tribunal in that context, we say, are particularly sharpened. And as already those particular duties have been sharpened for this tribunal by the Constitutional Court and the CAC. Let me also just immediately say that I'm going to be referencing at places various authorities and quoting from them. To ease your burden, you needn't write anything down. I have provided a parallel note for oral submission, which is really a bundle of the oral references. So to ease your burden and so that you don't have to try and scrabble and scribble, I hope that that will be of some assistance. And at the appropriate time, I'll tell you where in that note the paragraph is, and that may help also in terms of my time. Let me then deal immediately with the first contextual point. I must stress this point. It's the Constitution's resonating impact. And I need to spend a bit of time here, precisely because Multichoice tellingly spends so little time. It relates to Multichoice's somewhat cavalier approach to the constitutional harm that's been identified by eMedia in this case. And Multichoice assiduously overlooks the constitutional impact of its own conduct. Now, cut to their bones, Multichoice says that the open view restriction doesn't impact truly on anyone because everyone can still watch their favorite sports and they can go to their friend's house or they can go to the pub or the local church hall or they can buy a DSTV decoder if they want to watch the sports that they have otherwise become used to watching. But that, with respect, is so obviously hollow. And as I say, Mr. Marriott will deal with that in detail. Because let me just, as an obvious point, say, if that's so, if it's so that everyone can still watch anywhere, but just with a little extra trouble, then why force the SABC to sign an exclusivity arrangement like the open view restriction in the first place? And the truth is that the restriction does hurt, and it's intended to hurt. And it's imposed because it does competitive harm to e-media, which is the only meaningful competitor to Multichoice. But that's not my focus. For now, and much more critically, the response by Multichoice is deeply dismissive of the rights in issue and the constitutional harm of its conduct, because Multichoice's insistence on the open view restriction hurts far more than e-media. The impact of its conduct is on the rights of the viewing public and, of course, of their welfare as consumers of the SABC's television. And we're talking about literally millions of people who are affected. That's precisely why Multichoice was so revealingly wanting to neutralize the SABC's evidence. But it's too late for that. This tribunal cannot close its eyes to what the SABC tells it for the reasons that Mr. Farlam, I think, has already, with respect, correctly prefigured. The SABC confirms in its heads what type of sporting events we're talking about and the numbers of people affected by the open view restriction. And so you see this in the SABC's heads, quoted for you in the oral note at paragraph 1 of the oral note, if you just want to make a reference for yourself. And if you wish to turn there, well, all the better. But in the oral note at paragraph 1, you'll see we've quoted what the SABC says in their heads. The SABC has said this. It's clarified that between 20 and 25% of its viewers watch SABC programs through OpenView's platform, or eMedia's OpenView platform. So approximately a quarter of the SABC's viewers are unable to watch sporting events for which the SABC has secured sub-licensed rights. We're talking about matches in the 2023 World Cup Rugby, the 2023 World Cup Cricket, and South African Premier Soccer League matches if the SABC is contractually prohibited by Multichoice in its sub-license from allowing such events to be broadcast over the OpenView platform. At paragraph 17 of its heads, the SABC goes on. It says, it has also confirmed that as it is Multichoice's invariable practice to insist on the open view restriction or something equivalent thereto, which has been insisted upon by Multichoice and inter alia the sub-license agreements for matches in 2023 Rugby World Cup, 2023 ICC Men's Cricket World Cup, 2023 Women's T20 World Cup, semi-final and final of the Rugby World Cup, of the Rugby Curry Cup, certain PSL matches, and so on, and goes on. They say in the end of that paragraph that it can thus reasonably be expected that any future sub-licensed rights which the SABC is able to obtain from Multichoice will contain such a restriction. To each of those cases, they're the e-media cases, and you may well be aware of them. In August of 2022, in the e-media CAC judgment, Justice Victor said the following, recognizing, of course, interim relief should only be granted in exceptional cases, but granting it nonetheless there, and saying this. She said, competition law must be sufficiently agile to meet the needs of our fast-paced economy when considering interim orders, because if a too rigid approach is adopted by the authorities, the very interim relief may soon lose its relevance. She said, currently, this is about a basic satellite platform, but with the rapid development of digital technology, let me pause. Our case is also about the rapid pace of digital technology because of the threat coming very soon of digital migration, which has been finalized this year. That's exactly what Justice Victor was also referencing there. Let me continue with the quote. She said, this may soon become dated, hence the need to appreciate and understand the commercial exigencies and the urgency when interim relief is sought. Delaying decisions until the main relief is decided may result in irreparable harm. And for example, she says the relief in the main case may be appealed, and this can take several years to reach the Constitutional Court. Meantime, if there's irreparable harm, it will continue unabated. In that case, Justice Victor found that the way in which e-media had found itself subjected to Multichoice's dominance to kick off e-media's channels from its platform was a violation sufficiently of Multichoice's dominance to justify an interim interdict. But the facts of the present case, we say, are even more stark. And the result is not only irreparable harm to e-media, but it's also significant harm to consumer welfare. And here again is the critical point, as well as the public broadcaster and its viewers who have public rights to the public good. So for now, that underlines the point we need to look at next, which is constitutional harm. When you read in MultiChoice's heads that e-media's reliance on constitutional rights is, and these are their words, utterly absurd, well, you'll ask yourself whether such regrettable epithets are appropriate. And we would respectfully submit that for 4 reasons, by which I want to finish. It's a mistake for the constitutional implications of this matter to be dismissed in that pejorative way. Here's the first reason. That approach is unfortunately reflective of the dismissive attitude towards the very same type of constitutional arguments that have been raised by e-media in previous cases. In those cases, also involving viewers' rights and consumer welfare, you'll know MultiChoice refused to renew a contract with e-media and thereby affected the rights of viewers to continue watching particular e-media channels on DSTV. Well, in that case, we were also criticized. On a previous occasion, one of MultiChoice's previous counsel, not involved today, quipped that e-media was resorting to the vibe of the Constitution. Well, the Competition Appeal Court set MultiChoice right. It said this, and it's referenced for you in the oral note at paragraph 6 of that note. The CAC emphasized the need for a transformative constitutional approach to interim relief. And here's the important point. It underscored that unless this transformative approach is applied even at an interim stage of proceedings, then the historical and insidious unequal distribution of wealth in South Africa will continue. And the court therefore concluded that in granting or refusing interim relief, this transformative context must be considered. So that's the first point. The CAC has already corrected MultiChoice, and with respect, the tribunal should do the same here. Second reason why the dismissive approach taken by MultiChoice is mistaken is this. It has adopted an absolutist position that puts its financial and commercial rights above everything else, including the national interest, frankly. But that could never justify ignoring the rights or the consumer welfare issues in this case, or override, obviously, the SABC statutory duty to televise on free-to-air television and the constitutional rights of viewers. So this is a duty, again, recognized under the ECA, but also by the Constitutional Court. And we've, again, if you look at the oral note at paragraph 7, we've quoted the important judgment of the Constitutional Court in the SABC versus the NDPP in our heads for e-media at paragraph 108 of those heads. But as I say, this is captured for you at the oral note, paragraph 7. This is what was said by the Constitutional Court there. In SABC, the Court, in emphasizing the right of the public to be informed and educated, noted that this was acknowledged in the preamble to the Broadcasting Act, which reads, noting that the South African broadcasting system comprises, and I'd ask you to underline, public, commercial, and community elements, and the system makes use of radio frequencies that are public property and provides through its programming a public service necessary for the maintenance of a South African identity, universal access, equality, unity, and diversity. So when MultiChoice inserts itself and its dominance into the contract between the SABC and e-media, it cannot do so with respect, with a myopic focus only on its profits. It must, and the tribunal must, be acutely aware of the fact that there is an involvement here of public goods. There is public property, there is the public service provider, and it is the public that is entitled to receipt of these public goods. And you have the SABC in these very proceedings confirming why it needs e-media alongside it as a public partner in that broadcasting. Here, you can see that at the oral note at paragraph 8, we have cited for you from our heads of argument what is said by the SABC in its own answering affidavit in this case. There, the SABC, you'll see, explains, and we're quoting from their answering affidavit, in broadcasting the SABC's channels to around a quarter of the SABC's national audience, e-media assists the SABC to fulfill the public's rights of access to information and expression and to discharge its mandate under Section 8 of the Broadcasting Act to make its services available throughout the Republic. That we would commend to you as a critical quote by the SABC itself, recognizing that it partners with e-media in order to discharge that public duty. So simply because MultiChoice paid for premium sports content does not permit it to dominate the terms of their further use as a public good. And dominance does not permit abuse in the name of profits. Profits for MultiChoice alone. As the Chief Justice said in Mediclinic, and here this is quoted for you in the oral note at paragraph 9. The Chief Justice in Mediclinic said this, He said at paragraph 3 of the Constitutional Court's judgment, it ought never to be accepted for any of us, including the corporate citizens of this land, to indulge, talk less of overindulge, in the unconscionable practice of seeking to record the highest profit margin possible by any means necessary in wanton disregard for what that would do to the rest of humanity. There's a third reason why MultiChoice's dismissive approach is, with respect to them, mistaken, and that is that however much MultiChoice would wish to ignore or not deal with this duty, that is not a luxury open to this panel, because it's a particular duty that is placed on these members. That duty has been articulated in reinforcing ways by the Constitutional Court and by the CAC. Let me start with the Concourt. The former Chief Justice in Mediclinic was directing his instruction to these types of institutions, such as yours, in taking action to prevent against these types of abuses. He said this as a matter of opening principle at paragraph 5 of his judgment. That's quoted for you in the oral note at paragraph 9. You'll see in paragraph 9 of the oral note what is said in paragraph 5 of the Constitutional Court judgment, saying this sight must therefore never be lost of the central purpose for the enactment of that act and for the investigative structures that it gave birth to and adjudicatory structures. To sharply channel the focus to where it belongs, to remind all of us and ensure that the fundamental challenges sought to be remedied through this act and allied institutions are never left out of consideration. And importantly, for what I'm about to say next, you'll see that the Chief Justice in that paragraph said that in order to appreciate the fullness of this duty, it was necessary for him to quote the preamble of the Act in its entirety. I won't read the preamble to you, you'll be glad to know, but if I might lift out just three portions of what the CJ has quoted there, because they powerfully could have been written just for this case. The first one is, and you'll see I've underlined it in the oral note at paragraph 9, is to provide for markets in which consumers have access to and can freely select the quality and variety of goods and services they desire. That's seemingly appropriate, obviously, in this case. As I say, that line could have been written for this case. The next is the second underlined paragraph, which is to restrain particular trade practices which undermine a competitive economy. You're dealing with such a trade practice right now in regard to the sub-licensing and the inclusion of the restrictive clause. And then finally, the last section where the Chief Justice noted that it is to detect and address conditions in the market for any particular goods or services or any behavior within such a market that tends to impede or restrict or distort competition in connection with what? The supply or the acquisition of those goods or services within the Republic. We're talking about precisely the supply of these goods, and not just any goods, as I've said, public goods. So the Chief Justice articulated that duty, and he did it in paragraph 7, which is again part of the oral notes paragraph 9 for you. He said, institutions are created to breathe life into these critical provisions of the Act, and they therefore must never allow what the Act exists to undo and to do, to somehow elude them in their decision-making process. So when we ask you to keep these thoughts in mind, we do so in your decision-making process. And he makes it clear further that it's necessary to do so in order to also avoid the legal sophistry or right-sounding and effectively inhibited jurisprudential innovations that he says must be vigilantly guarded against. So that's the Chief Justice. Notably, MultiChoice does not engage squarely, members of the panel, with eMedia's argument regarding the constitutional lens. Its heads of argument don't reference Mediclinic at all, as far as we can see, and they don't deal at all with the argument around the transformative constitutional approach that's set up by the CAC and eMedia. Instead, as I've said, its response is to abjure. It says in relation to the constitutional argument by eMedia around section 16 of the Constitution, which protects the right to information, it says that the argument is, in its words, utterly absurd. Well, with great respect, we prefer, and so should the tribunal, what the Constitutional Court has had to say about section 16 in this context. Section 16 of the Constitution says everyone has a right to freedom of expression, including the freedom to receive information. And the constitutional right to receive information gives effect to openness and to nation building and to these as founding values of our democracy. And the Constitutional Court in Islamic unity recognized that in the context of broadcasting, it's in the public interest that people be free to receive information. It held further that a restriction placed on broadcasting limited the constitutional right of viewers to freedom of expression. And the Concourt reasoned that and I'm quoting now, it's, you'll forgive me, it's one of the quotes that I wasn't able to in the time get into the oral note for you, but I will provide it afterwards. But if you would just listen to what the court said, it said, the broadcaster itself potentially has a wide audience that would be deprived of information that it would receive, but for the prohibition. And so we say that the continued enforcement of the open view restriction would deprive, on the SABC's own showing, millions of South African households of access to information in the form of broadcasts of premium sports fixtures and participation in such events of national interest. And that context-specific and constitutionally sensitive approach is demanded by the tribunal because of the jurisprudence of the e-media CAC decision and Media 24 by the Constitutional Court. Let me very, very briefly tell you what was said in Media 24. That's in the oral note at paragraph 10. You'll see we've quoted Media 24 by the Constitutional Court. And the Constitutional Court in Media 24 said this at paragraph 30. It said, this is because the Act was enacted as transformative legislation. Section 2E and F of the Act states that part of the purpose of the Competition Act is to ensure that small, medium-sized businesses have equitable opportunities to participate in the economy, to promote a greater spread of ownership in the economy by those who are disadvantaged by apartheid. And the court therefore says that equality is an animating feature of the Competition Act. But then the critical paragraph is paragraph 31. Section 8 of the Competition Act is an important component for the achievement of the purposes contained in sections 2E and F, because Section 8 prohibits dominant firms from abusing their power to the detriment of the market and consumers. Consumer welfare lies at the heart of the matter before us. The prohibition of abuses of dominance is recognition of the fact that dominant firms attained this status due to our exclusionary history. And consequently, the court finishes in that paragraph, when a court interprets the extent of the protection contained in Section 8, it must do so in line with the purposes of the Act and the Constitution, as abuses of dominance and the resultant monopolies have the potential to perpetuate historic patterns of exclusion and inequality. And then this tribunal knows well, I think by now, certainly the e-media finding by the CAC. That finding, no less, was a finding against Multichoice. And in that finding, the CAC drew the Constitutional Court's principles in Mediclinic into the heart of these very types of matters for interim relief against an abuser of dominance and in contexts where viewers' rights are at stake as a component of consumer welfare. And it did so while stressing, I have to put this point again, it did so while stressing that its protections were actualized to protect e-media as an historically disadvantaged company from Multichoice's abuse of dominance. And we saw that in the CAC's decision. It's quoted for you in the oral note at paragraph 11. And you'll see what I've already stressed, which is the CAC emphasizing the need for such a transformative constitutional approach, even at interim stage of proceedings. And then the CAC criticized the tribunal for failing to pay sufficient attention to the context and purpose of the Act. And it said, importantly, such attention was required to be exercised by Multichoice. Why? Because there are high levels of economic concentration in this basic satellite platform, which can easily result in economic exclusion. And in granting e-media interim relief, the CAC sought to prevent the exclusion of what it called a black-owned, medium-sized competitor like e-media that was just gaining traction in the basic satellite market. So, in the current application, e-media is again coming and seeking injunctive relief against Multichoice's abuse of dominance. But we know that it is entitled, it doesn't need to be embarrassed to ask the tribunal to do so in order to undo that which was the abuse of dominance in a particularly and uniquely South African context. And then finally, there's a fourth and a related reason why a constitution-free or a right-dismissive approach to this case is mistaken with respect. And that is that the tribunal, quite aside from what the CAC may have said, the tribunal is bound by the Constitution itself. It's bound by Section 7 of the Constitution. You may know that Section 7 says that the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. And we know that the rights in issue in this case are the rights to freedom of information. Well, Mediclinic, the Constitutional Court judgment, which we've referenced repeatedly, says this at paragraph 10 through the Chief Justice, and it's at the oral note, paragraph 12. The reference is there for you. The Chief Justice said this: not only are courts an integral part of the state machinery arguably under a Section 7.2 obligation to promote, protect, respect, fulfill rights in the Bill of Rights. But the tribunal and the CAC have the added responsibility to do so, imposed on them by the preamble to the Act and its purpose. So this tribunal has its own constitutional and competition law overlay to respect, protect, and promote the rights in the Bill of Rights. So it cannot shut its eyes, firstly, to the evidence of the SABC. It needs to take it seriously. And it cannot shut its eyes to the impact on consumer welfare overlaid by constitutional rights. And it has to ensure that it acts as the safeguard against Multichoice, which now insists absolutely that it has commercial rights which must be respected. It has not just sought to sterilize the FTA rights and the public goods that eMedia assists the SABC to fulfill by broadcasting to millions of SABC's viewers. It would also seek to immunize from close scrutiny by yourselves, this tribunal, all of those important constitutional aspects which we say are utterly vital to the outcome of this case. And that is particularly so, if I might conclude on this point, by highlighting that there is at the heart of this case a peculiarity. It's OpenView's insistence that it may rely on an exclusivity clause. But the Constitutional Court has ruled already that such a right is not generally recognized as worthy of protection before that court, the Constitutional Court, in Pick and Pay. It said, as you've seen us quoted in the heads in the Pick and Pay case, that our law does not usually recognize an exclusive right to trade as worthy of general protection as a matter of constitutional law, precisely because it undermines the idea of competition and making it less free. Now, if that is so as a general principle, and we accept that it's a general principle, but if it's a general principle, how much more so where the exclusivity clause has all the deeply unattractive features that I've already highlighted in this case? Multichoice buying up the rights, sterilizing them to prevent their use by its competitor, the only real competitor in the market, and thereby denying millions of viewers of their rights to watch national sporting events on free-to-air television through an inducement that has been forced upon the SABC not to discharge its statutory obligation under the Broadcasting Act. So let me conclude, if I may, in 2 minutes before I hand over to Mr. Marriott. It's been necessary for me to deal with these framing principles because they frame why the relief has to be granted as a matter of constitutional outcome. And I must stress this. We do not lay claim to the Constitution for effect or to posture. We do so because it's an animating and vital feature of this case, which entails competition harm overlaid with constitutional harm. And the relief sought cannot properly be determined. Your discretion as a panel cannot properly be exercised through only a competition law lens. And that is for the 2 reasons I've given. The first is that the protection sought by eMedia is demanded as a matter of the Constitutional Court and the CAC's binding case law that says that you have as your purpose as the tribunal the protection of the Competition Act as understood through the prism of the Constitution. And second, because the tribunal is duty-bound to consider its discretionary powers, particularly in relation to Section 49 and interim relief, sensitive, acutely sensitive to its duty to respect, protect, promote, and fulfill the constitutional right to receive information, and which right Multichoice's conduct through the impugned exclusivity clause is violating, and by interfering with eMedia and SABC, partnering to provide a public good. So in that context, we say that we seek the following relief. We seek interim relief to empower eMedia, an historically disadvantaged company as recognized by the CAC, to be protected from an abuse of dominance by its competitor Multichoice. But we seek interim relief for a purpose that's not only in eMedia's interest. Also, we protect that which is just and reasonable in the public interest and to protect against constitutional harm. And as opposed to that, you have Multichoice's arguments that amount to a stronghold position. They say we've paid money for our commercial rights and we assert them strongly, but entirely missing with respect for Multichoice's commercial stronghold position is that it's actually a stranglehold. It's not only trying to choke off eMedia, its only competitor, it willingly is strangling the SABC and thereby its millions of viewers from their ability to continue watching sports as a public good. That private commercial insistence must therefore be assessed against, and we say must yield to the national interest and the public good. Mr. Marriott will then take the remainder of our time, Mr. Chair, and panel members to deal with why the relief must be granted as a matter of competition law, in fact, unless there's anything I can assist with now.
Yes, let me check if the panel has questions for you at this stage. Professor Vilakazi.
Yes, Chair, just a quick one. Thanks, Mr. Du Plessis. Just a question on the point you make around the public good, and that e-media, in a sense, assists the SABC to start discharge its duty, right? And I think you've made much, obviously, about the public benefit of this. Can I just check the kind of factual position here as well, right? Because I presume this is not entirely an altruistic kind of good citizen position that e-media adopts, right? And I think in your papers, at least in the founding at 136.2, and you needn't go there, but e-media says, look, we actually don't get much revenue from carrying these channels. Can you just clarify then that in totality, the fact that e-media carries the SABC channels on OpenView is entirely uncommercially beneficial to e-media? So is it an absolute favor, or is in truth considered more broadly a case where there is actually some commercial benefit, at least at the level of the package of OpenView presented together with other channels? Yes. What are we actually saying here about this this assisting the SABC?
Yes. So Professor Vilakazi, you put your finger on the crucial aspect of this case, which is that Multichoice repeatedly talks about the free riding, supposedly, that e-media is benefiting from, but that's simply not the case. And what we are able to show you, and I think it's at clause 7.3, page 108 of the papers of the carriage agreement between e-media and SABC, or the carry agreement, is that you'll see there that the SABC in fact pays e-media to get access to e-media's platform. And so SABC is doing so, and with respect, this sort of puts the cherry on the point.
Sorry, Chair, I think this is confidential, probably.
I thought. Excuse me,
but anyway, but I mean, it's there. They don't. It's true. They don't. The facts are there, but I just thought I wanted to mention that.
Let me not mention any details whatsoever, but the clause is there. And so the arrangement is one by which e-media is, through that, clearly in a partnering arrangement where it assists in that context. E-media doesn't make any money out of being able to advertise on these channels. It's not its channels to advertise on, the SABC's channels. And all it does is it obviously ensures that its platform is available in that context. I should say that, of course, any further aspects around the actual dynamics, to the extent that we need to go into confidential discussion around them, would probably be best done in that context and with Mr. Marriott's assistance.
Ms. Mzwai?
No questions at this stage.
Just one question for me, Mr. Du Plessis. All the contextual points that you have made, where do we consider that under the test for interim relief? I heard you speaking about harm. Does it only relate to the assessment of harm, or also the prima facie restrictive practice and its effects?
Yes.
Was Mr. Marriott going to deal with this, to just tell us, you know, how do we apply this when we apply the test?
Yes, he will certainly elaborate, but let me say immediately. So the CAC, through the judgment by Justice Victor, made it clear that in this particular space, you have to be what it called context specific. So it's firstly an alert to you that these constitutional aspects require you to recognize the broader context of what is taking place through the power that you've been asked to exercise. You can't shut your mind, in other words, to the much broader implications of what I've been highlighting. So the context specific nature of the test, it means that every aspect of what you're doing in terms of interim relief under Section 49 must keep that context in mind, more broadly speaking. But of course, it would also mean that the rights in issue, the question of whether rights have been shown, would immediately be something which we'd say very strongly have been shown to be impacted here. The rights not only of e-media, but also the rights in relation to, of course, the rights of the public that we've mentioned. And it would also be under the rubric of anti-competitive effects. So it really is very difficult to do a slice and dice and disaggregate. It is to recognize in the Constitution, and I think the Constitutional Court's judgment in Mediclinic makes this clear as well, it's in your decision-making process. In other words, in entirety of your process, where it may actually play out, we suspect is in different ways, in different features. But as I say, Mr. Marriott will elaborate on all of those.
Okay, thank you. Before we move to Mr. Marriott, I would like to take a tea adjournment at this stage. So can we return at 12? And
Yes,
we will
thank you,
hear
Chair.
from you.
Thank you.
Thank you.
Want to check that all council is back? Just waiting to see Professor Vilakazi. Marriott, you may continue.
Yes, thank you, Chair. Just to firstly pick up on your question to Mr. DPC. His submissions, in my respectful submission, find their most suitable home under the rubric of anti-competitive effects. It has been the jurisprudence of this tribunal that when you consider anti-competitive effects, you will consider consumer harm and you will consider competitor harm, for want of a better tag. Following Mediclinic and eMedia's decision and the eMedia decision in the interim interdict, in the last interim interdict application, part of your task in considering anti-competitive effects is to do so through the constitutional lens, and that is a relatively straightforward issue or task to do for consumer harm, because of course consumer rights under the Constitution tally comfortably with consumer welfare considerations under the Competition Act. So that everything that my learned friend Mr. du Plessis said about consumer harm and the public interest sits easily within the anti-competitive effects inquiry into consumer welfare. Similarly, in considering competitor harm, you will have regard not only to what we might call the traditional economics of the exclusion, foreclosure, and the like, but you will also consider the context in which that exclusion and foreclosure takes place. In other words, you will ask, what is the structure of the market in which that takes place? What is the history of that market? Why is it that it has the bars to entry and high levels of concentration that it does? You will ask, who is being excluded? Is it somebody that will aid transformation, or is it a firm that will not do so? These are the issues to which this tribunal must now have regard. Of course, it always had to have regard, but which has now been made clear, are paramount in considering the anti-competitive effects of conduct of a dominant firm in this case. With that background, or with that submission having been made, I, as my learned friend Mr. du Plessis has made clear, will deal with market definition and dominance, exclusion, and anti-competitive effects. I'll also deal very briefly with balance of convenience and irreparable harm, but my submission ultimately will be that the irreparable harm inquiry is wrapped up in the consideration of the anti-competitive effects on eMedia, and the balance of convenience is equally taken care of when one has regard to the justifications advanced by Multichoice for the what has been called the open view restriction. The facts in this case are straightforward and they're not in dispute. Multichoice, or Supersport, procures the exclusive right to broadcast a range of sporting events on Supersport channels, which form part of the DStv bouquet. Generally, these rights are split into pay TV rights and free-to-air rights. Sometimes Multichoice procures only the pay TV rights, always on an exclusive basis, but it does so it only secures the pay TV rights. Other times, it procures both the pay TV rights and the FTA rights.
And in those circumstances, it is often, more often than not, required by the head, the rights owner, be it the Football Association or the World Cricket or World Rugby, to sublicense those rights to a free-to-air broadcaster. If it's not required by the sporting body itself, it's required under local legislation, which requires that Multichoice not hinder the free-to-air transmission of sporting events in national interest. So it's not a voluntary thing which Multichoice does invariably in sublicensing these rights to the SABC. It is, as a rule, required to do so, and that is why it does so. Now, the events that led to this application were the Rugby and Cricket 50-over World Cup that were held at the end of last year. Multichoice held the exclusive pay TV and free-to-air broadcast rights for those events, and it sublicensed those rights at the 11th hour. In fact, after the events had started, at least in respect to the rugby, to the SABC, but on subject to a restriction that the broadcast of those events would appear only on SABC's platforms or SAB's broadcasting platforms. They would not appear on third-party platforms such as OpenView. Now, as everyone knows, except perhaps for those OpenView viewers that wanted to watch the rugby on SABC2, we won the Rugby World Cup, and that victory was probably the highlight of 2023 for South Africa as a country. It attracted enormous viewership and interest and following. And the people that were unable to watch that match, the only people that were unable to watch that match on the SABC are those who had chosen to purchase an OpenView decoder. The practice, while the Rugby and Cricket World Cup has come and gone, the practice is ongoing, and as my learned friend Mr. Du Plessis explained with reference to what the SABC has said, there are a number of sporting events likely to happen over that will happen over the next few months, which will be the subject of the same restriction. PSL soccer matches, the Nedbank Cup, the MTN Cup, the ICC T20 Cricket World Cup, and Currie Cup Rugby, to name a few. Now, one of the issues in dispute, which Multichoice has disputed, is they say, well, this OpenView exclusion, as eMedia has called it, is not an exclusion which is directed at OpenView. It is directed at all platforms, all third-party platforms. In other words, if there was another platform, another free-to-air broadcaster through which the SABC could broadcast its channel, it would be caught by the provisions too. The debate is somewhat academic because in practice, this restriction only affects, and is no doubt intended to affect, OpenView. There is no bar, seemingly, to the SABC supplying SABC channels incorporating the sporting content to the likes of Centec or to Starsat. The only platform affected is OpenView. And as the SABC says in its affidavit in paragraph 27.1, it does appear to be an exclusion directed at eMedia. Why? Why is it directed at eMedia? Because eMedia is Multichoice's only viable, is the only viable potential and existing competitor as a broadcaster to Multichoice. And Multichoice is desperate to ensure that its overwhelming and long-standing dominance as a broadcaster in this country is maintained. It is regularly, and should I add in that context, analog switch-off is only going to compound the situation, because as is explained in the papers, DTT is not a viable platform going forward. And so as analog is switched off progressively over the course of this year, the only two viable platforms through which the SABC can distribute its programming will be Multichoice and eMedia. Multichoice knows that, and therefore it does what it can to ensure that it is ahead in the race to secure the lion's share of viewership in this country. Multichoice is, as a result, regularly before the competition authorities for precisely that reason. It was here about the encryption of set-top boxes. It was here about the removal of eMedia's entertainment channels. And it is here again now. In its address, Multichoice is going to tell you how the relief sought by eMedia in this application is nothing more than an attempt by eMedia to free ride on the investments made by Multichoice to secure the exclusive rights to broadcast these sporting events. It will tell you about the risks that it takes in securing these sporting rights, and it will point out that eMedia has not sought to obtain those sports broadcasting rights for itself at any point. These arguments are misplaced. Whether deliberately or not, they mischaracterize what this case is about. Let me tell you what it's about from eMedia's perspective. The effect of the OpenView restriction is that any customer that chooses to watch the SABC on OpenView cannot watch the sporting events that are subject to the OpenView restriction. What they are treated to instead is reruns of provincial games, provincial matches of the same type of sport. That is clearly harmful to the reputation of eMedia. Indeed, that's the harm which this restriction is no doubt intended to inflict upon OpenView. Stripped to its core, this restriction is nothing other than a restraint imposed upon the SABC with the intent of humiliating OpenView in the eyes of its viewers. It's not about competition on merits. It's not about enabling DSTV to sell more decoders or sign up more subscribers. They tell you nothing of that in the affidavits. It's about hurting the only other viable satellite broadcasting platform in the country. And it's that conduct and the resulting harm to eMedia which the relief sought in this case is intended to ameliorate. Now, I deliberately haven't dealt with the consumer welfare aspects of it because Mr. du Plessis already has. I deal with it from eMedia's perspective. So from eMedia's perspective, this is not a case about eMedia securing rights to broadcasting events. It's about preventing damage to eMedia's brand and reputation, which is occasioned by the OpenView restriction. So eMedia is not concerned about getting access to the rights per se, but rather about the fact that the sublicense to the SABC having already been granted, Multichoice is using that sublicense quite deliberately to damage eMedia's reputation. It's OpenView's goodwill with its viewers by compelling the SABC to exclude the sporting broadcast from its channels when they are supplied to OpenView. And the evidence regarding this, the damage to its goodwill, is included in the founding affidavit, but it's in self-evident. Consumers who found out that they couldn't watch the normal SABC programming on the SABC during this critical time, the Rugby World Cup matches, were outraged. They wrote to the Broadcasting Complaints Society. They explained that they had, some of them, and I refer in this regard to page 211 to 216, they explained that they weren't able to run out and get another platform, sign up to DSTV. They're not in a position to simply seek other means of watching the rugby, and they have been misled, and they were angry, and they directed that anger at eMedia, so that the harm to its goodwill is clear, and it is no doubt the purpose of the OpenView restriction in the first place. When I say this is not about procuring rights for free, consider the following thought experiment. If the SABC sublicense had never been granted at all, and this content didn't appear on normal SABC channels, the eMedia would not be here. It's not, even in these proceedings, eMedia doesn't seek a sublicense from DSTV. All it seeks is the removal of these damaging and vindictive restrictions included in the SABC sublicense. That illustrates the point I make. This is not about free riding. It's a case which is concerned with a decision that Multichoice made to sublicense its rights. And then having made that decision, elected or compelled to grant a sub-license used the opportunity to damage OpenView. That's what this case is about. And we say that a restriction which serves no purpose other than to damage the reputation of a competitor is not legitimate and can never be justified. Now, another point made by Multichoice in various contexts in its heads of argument is that the OpenView restriction is not a restriction at all. Because, if I can paraphrase or recast the argument, an intellectual property right, such as copyright, they say, is actually a bundle of rights. They don't use that term, but that's, as I understand, what they mean. And if I, as the rights holder, grant you a license to exercise or exploit only some of the bundle, then it can never be a restriction on you for me to demand that you don't exercise other parts of the bundle of rights. So, for example, if I grant you a license to exploit a patent or a copyright in Gauteng, Multichoice says it's not in fact a restriction to prevent you doing something in KwaZulu-Natal because you never had that right in the first place. That argument you will see, for example, in paragraph 5 of my learned friends' heads, but it comes up routinely and frequently through the course of their submissions. It's one that is commonly advanced by IP rights holders, but equally commonly rejected. The Football Association case, to which we sent through this morning and which I shared with my learned friends overnight, is an example of precisely why you can't use the grant of a limited license to do part of or to exploit part of an IP right to gain an anti-competitive advantage in respect of another part of that right. And as I say, the Football Association case is a good example of that. What happened there was the rights to watch the Premier League or to broadcast the Premier League soccer in England were granted firstly to B-Sky B in the UK, but they were granted separately to Multichoice Hella in Greece. Multichoice, however, sold devices in Greece with cards that pubs or bars in the UK could plug in and receive the Multichoice signal in the UK. And obviously it was cheaper for the pubs to get the content through that means. And so some of them did that. Obviously FIFA wasn't happy with that. So what they did is inserted a provision into all of its licensees agreements, which required them, to ensure that their signal was not received outside of the territory in which they were licensed. In other words, Multichoice would say of that restriction, well, it's not actually a restriction on Multichoice Greece, because Multichoice in Greece was never granted a right in the UK in the first place. But that didn't stop the authorities in the United Kingdom striking the provision down on the basis that it contravened European competition laws. It said at paragraph 117 that the provision, if I can refer, I think I don't want to spend too much time, but it said at paragraph 108 that the intellectual property does not guarantee the rights holders concerned the opportunity to demand the highest possible remuneration. And that harks to something that Multichoice says repeatedly. It says we could have charged the SABC more without this restriction. Well, IP rights don't guarantee you the most or the highest possible remuneration. As was said in many clinic, sometimes profits have to give way to the interests of competition. And it says then later in paragraph 117 that having regard to the foregoing, it is conclusion that the restriction which consists in the prohibition on using foreign decoding devices cannot be justified in the light of in light of the objective of protecting intellectual property rights. You can't, in other words, say that just because I've licensed you to do X, I am entitled to prevent you doing Y. Each case has to be assessed on its own facts and the merits and the conclusion and assess whether that restriction gives rise to anti-competitive harm in a relevant market. And that's what the open view restriction is. It's a restriction on the SABC, preventing it from operating outside the scope of its license. But it's an abusive restriction and therefore remains subject to competition law scrutiny in exactly the same way that the restriction on MultiChoice Greece remains subject to competition law scrutiny, despite the fact that MultiChoice Greece never had a right to broadcast these events in the UK. It's also not correct, as MultiChoice appears to suggest, that the grant of an exclusive license to exploit intellectual property is somehow immune from competition law scrutiny. There are many examples of cases in which IP rights holders, and indeed head licensees, have been held to have abused their dominance through the implementation of restrictive provisions in their agreements with firms that exist downstream of them on the back of an exclusive right. The Fila case in Australia is an example of this. Fila was appointed as the exclusive apparel distributor of 5 Australian Football League teams, but their license was limited to distributing the official kit. They used that license, that exclusive license, to threaten retailers and said, if you obtain non-official kit, in other words, supporters kit, from people other than us, we won't supply you with the official kit. That was a clear abuse. And the parallel here is obvious. MultiChoice, as the head licensee, is telling the SABC that it can have these rights, but only if it doesn't deal with the media. In exactly the same way that Fila was telling the retailers, you can have the official kit, but only if you don't deal with any of our competitors insofar as unofficial supporters kit is concerned. The Nike case. Nike used a series of measures to ensure that its licensees in territories in Europe only made sales in those territories. I don't deal with all the detail, but that, the court found, led to an artificial compartmentalization of the European market and gave rise to an abuse. The same compartmentalization arises in this context. MultiChoice is saying to the SABC, you'll only be granted a sub-license if you ensure that this broadcast content doesn't find its way into a rival satellite broadcaster's feed. No different to saying, I'll sell you the goods, but only if you ensure that they don't find their way into other markets in respect of which you are not licensed. And it's that artificial compartmentalization that lies at the heart of this case. It prevents competition on the merits in the satellite broadcasting market. It is a restriction which MultiChoice has imposed in respect arising from its exclusive FTA rights, but which it has used to achieve an advantage in the satellite market. With those introductory but with respect important issues dealt with, I want to deal briefly then, sorry, not briefly, but I want to deal more particularly with the specifics of this case from a market definition and exclusion and competitive effects concerned. The market definition question is relatively straightforward. These are interim interdict proceedings. The starting point is therefore Emedia's version. It is explained that MultiChoice is dominant in the markets in which exclusion occurs and in which the anti-competitives, in which the conduct arises and in which the anti-competitive effects are sustained. As to the former, Emedia explains that MultiChoice holds the rights to broadcast the overwhelming majority of sports events broadcast in this country. It gives a figure of 90%. And it is therefore a dominant firm in relation to the acquisition and supply of premium sports content in this country. Now, you would have to be hiding under a rock for the past 2 decades for you not to know that MultiChoice's share, or Supersport's share, of the rights to broadcast sports broadcast content in this country is that high. But, says MultiChoice, hang on, there may be other rights which have never been purchased, which you could purchase, and which would therefore increase your share of the sports content that has been acquired. But that doesn't assist MultiChoice. The fact that there are other rights that could be acquired has no bearing on the market share or market definition question. It's a bit like saying, you know what, if you sold your goods at very, very low prices, you could actually increase your market share. Make a mockery of them, because there's always things that you have no, sorry, I should have started with, you have no idea what value has been attributed to the rights that have not been purchased. The fact that they haven't been purchased says to you that they that MultiChoice didn't want them, or that the SABC didn't want them or couldn't afford them, or that there was no economic case for their purchase. Now, if that is so, how can it be said that their very existence means that MultiChoice doesn't have the market share which it claims it has? As I say, that is like saying you could make more sales. Well, of course, there will always be more rights I can purchase. But the question is whether they were purchased or not from a market share perspective, in the same way that the question is, were the sales made or not in an ordinary market share analysis. What is not in dispute is that where these broadcast rights have been acquired, it is overwhelmingly MultiChoice that has acquired them, and MultiChoice is therefore a dominant firm in the market for the acquisition and onward supply of the right to broadcast sports content. One could also, as we've said, consider the market more narrowly, because of course once MultiChoice has acquired these exclusive rights, it has enormous market power to do with them as it pleases, as the facts of this case illustrate. So we say it is clearly dominant in relation to the market for the acquisition and onward supply or onward sublicense, same thing, of sports broadcasting rights in this country. Then I should say, I don't have time, but I should say that the complaints that my learned friends advanced in the heads of argument at paragraph 77 about the lack of rigor with which this market has been defined don't bear scrutiny. The channel provision market has got nothing to do with the content. It's a separate issue, separate market, and the market for which we have contended, for which we've always contended, and which the SABC clearly understands, is the, as I say, the acquisition and onward supply of premium sports content. Then, insofar as the market in which the harm to e-media arises, this is a familiar territory. It's already been considered by the tribunal and the CAC in the entertainment channels case, and MultiChoice has already been found to be prima facie a dominant firm in the basic satellite market in which it competes with e-media. And if you have regard to the premium satellite market, the position only worsens, because only MultiChoice competes in that market at the moment. So on any basis, in the satellite market, however so defined, MultiChoice is a dominant firm. That then leads me to deal with exclusion. We rely principally on section 81D1. We say it's, again, a clear case of inducement. MultiChoice is inducing, indeed requiring, the SABC, which is a customer of Supersport, insofar as this packaged sport content or this broadcast sport content is concerned, not to deal with e-media, which is a competitor of DSTV. In their heads of argument, MultiChoice advances what I consider to be a contrived argument about suggesting that e-media and the SABC are not providing the same type of service to the SABC in this context, and therefore MultiChoice's conduct is not caught by the provisions of section 81D1. It's contrived because it has no basis in the wording of the Act. There is nothing in the Act which says that the inducement must pertain to a service that both parties provide to the inducee. They're simply rewriting the Act. In any event, MultiChoice and e-media do provide competing broadcasting services to the SABC. They both carry the SABC channels. So They do provide the same service, in fact, but it doesn't matter. The point is, the case that eMedia advances is the simple one. You, by including the open view restriction, are telling the SABC, which is a customer of Supersport, not to deal with eMedia, which is a competitor of MultiChoice. It's very straightforward. The second argument advanced by MultiChoice is equally weak. They appear to suggest, well, you continue to deal with, SABC continue to deal with SABC, with eMedia, because your channel still appears on the OpenView platform. But that with respect, doesn't bear scrutiny. The channel, the SABC channel, which now appears on the OpenView platform, is not the same as the SABC channel that appears anywhere else. That is because the SABC has been required not to deal with MultiChoice insofar as the sports content is concerned. The fact that SABC may still be at liberty to deal with eMedia in respect of other content like entertainment programs or your latest soapy is irrelevant. That can never be a defense under 81D1. It would be like saying, well, I as the dominant firm am preventing you from supplying mangoes to firm C, but that's fine because you can still supply apples. It's just totally there has no basis in the Act, and with respect is absurd. There is clearly an inducement not to deal. The not to deal relates to the broadcast sport content that is the subject of the open view restriction. And so far as Section 81C is concerned, we've made that case in the founding affidavit that the damage that is occasioned to the eMedia brand will prevent it in due course from expanding within the market, markets in which, or the basic satellite market in particular, in which it competes directly with MultiChoice, and that is indeed its purpose. MultiChoice will tell you about how OpenView is growing, and that eMedia has made it clear that its sales of set-top boxes are not dependent on acquiring or screening, on screening the broadcast content of a particular sporting event. But OpenView's growth has been achieved. I've got two answers to that. The first is that OpenView's success, such as it is, and we shouldn't overstate it, it's still dwarfed by comparison to MultiChoice. eMedia's success is dependent upon its continuing to hold MultiChoice to account. It's no answer to say, well, you've been successful in the past, so you can just carry on being successful. eMedia has to bring these sorts of interim interdict applications to ensure that its success continues. That's point one. Point two is that OpenView's growth has been achieved for a variety of reasons unrelated to sports content. We accept that. But it would have been greater, no doubt, had the OpenView restriction not existed. And it needs to be greater in order to give rise to a competitive constraint on MultiChoice going into the future, in particular, as the country converges into digital-only television, and we need at least two, but preferably more, viable platforms through which consumers can access content.
So, Mr. Marriott.
Yes.
Maybe before you move on, sorry to interrupt you, on your first point there, that part of eMedia's success is dependent on the ability to kind of, or its efforts to hold MultiChoice to account. And you kind of perhaps didn't really quite elaborate. Is it to say by taking MC to court regularly, well, somehow that explains what MultiChoice is arguing has been significant growth of eMedia over time anyway, in terms of the distribution of its decoders, et cetera, et cetera. So how do you respond directly to their point around the growth that eMedia has had, with or without, almost regardless of the sport content, which is what they say?
Well, what we're saying is that if the competition authorities are going to not have regard, I won't say ignore because you're not ignoring, but to dismiss applications such as these. Multichoice will be emboldened. It will engage in ever, as I said, this is the third issue that has arisen before the competition authorities. It will engage in ever greater efforts to ensure that its only viable competitor doesn't grow. That's what I mean. I mean that if you can't say, well, they've grown, therefore everything's fine. You've got to say, well, why have they grown? And what do I need to do as a tribunal to ensure that they continue to grow? And what can I do? And what you can do is ensure that the provisions of the Act regarding abuses of dominance are are strictly enforced, and abuses of this sort are brought to a swift end. That will enable media to grow, and that is what I mean when I say that part of its success is about holding Multichoice to account. It's not only in the context of this case, but it prevents whatever is the next strategy to prohibit or impinge on e-media's growth.
Maybe just on that then. So then what supports the second contention that in all likelihood, e-media, or at least the OpenView platform, would be even bigger or perhaps would have grown further if it had this kind of additional content without these restrictions?
I don't
Is there something we can look at to?
No, I can't point to direct evidence on that. I can't point to direct evidence on that issue. I'm saying it as a matter of common sense and logic. If the content on e-media has been artificially the quality of the content on media has been artificially reduced because now you have provincial reruns instead of the real game, then the goodwill in the brand would have increased, and that in time, of course, drives sales of OpenView decoders. But I don't have, obviously one can't quantify that, one can't, it's certainly not an interim interdict, but it's simply a consequence of goodwill. That is what goodwill is. It drives sales and it ensures, and if you undermine goodwill, then you undermine the ability to drive sales. I want to, in the time available, deal with anti-competitive effects. Given that time is short and Mr. du Plessis has in any event given, in my view, what is chapter and verse on the consumer harm, I don't intend to deal with that in any detail. He's explained the extent of it. He's explained, I have in addition referred you to page 211 to 218, in which which gives you a flavor of the sort of damage and frustration, sorry, not damage, the sort of frustration which consumers felt at not being able to view this content on the platform that they had already chosen and on which they expected to receive the ordinary SABC channel. Just to note on this question of consumer harm, in an argument which seems to run contrary to many other things they say, in particular about the justification for this OpenView restriction, Multichoice intends, as I understand their heads, to argue that, well, you know, there is this coverage, SABC, that these viewers haven't really suffered harm because they can view the rugby or the cricket or the soccer elsewhere. But that really has no basis in fact, because what are they going to do? They've chosen, they've invested. These are not wealthy people that can afford R1,000 a month premium subscription. They've invested in an OpenView decoder. They are now told, well, despite what they might have expected, they must now go and either, you know, sign up with StarSat, which is minute and probably and would therefore probably not be very attractive, or they must sign up with DSTV, which is of course exactly what Multichoice wants, but it's harmful to consumers that they would be compelled to do so. So the consumer harm is manifest. Those who have invested in OpenView decoder cannot now watch the content which they ought, absent this restriction, and to be able to watch. Competitor harm, well, again, clearly harmful to the SABC, which competes with Multichoice as a provider of channels to platforms. It is effectively prevented from accessing a significant proportion of its audience. The number, I'm not sure if it's confidential, it's at page 261, paragraph 36.4, and it's therefore significantly foreclosed from its audience. That is clear competitor harm. I should also note that section 60, my learned friends refer to it at page 100 of my learned friends from Multichoice. They refer to the provisions of the Electronic Communications Act, section 60, at what paragraph 100, page 100, paragraph 47.1 of their heads of argument. What that provision says, they say section 60 of the ECA provides that subscription broadcasting services may not acquire exclusive rights that prevent or hinder the free-to-air broadcasting of listed national sporting events. Well, the open view restriction clearly hinders the free-to-air broadcasting, because e-media is a free-to-air broadcasting, of listed national sporting events. So it's harm to SABC through foreclosure to its audience. It's harm which arises because it's contrary to the Act. And it's going to be much more significant following analog switch off. Because if this restriction, let's just fast forward a year, if this restriction is allowed to continue, there's only going to be 2 platforms that are operating. You've got a sub-license which says, Supersport, will grant you a sub-license to watch the ICC Cricket T20 World Cup, but not on e-media. What does that mean in effect? It means that the only place that the SABC will be able to screen these games and reach an audience of any significance will be Multichoice. So the sub-license effectively amounts to nothing more than the right of the SABC to put content which is already on channel 201 on DSTV, also on channel 161 on DSTV. It will become circular. The sub-license will become nugatory. Now, finally, on to e-media. I've explained it. It is the only rival in the rival platform in the basic satellite market. It's a potential rival in the premium satellite market. And the effect of the open view restriction is to hobble its ability to compete. Now, we see the usual complaints about, well, you haven't quantified this harm. You haven't said how many boxes you haven't sold. But of course we haven't. It's impossible to do so. That's why we seek the interim relief that we do. It is impossible to give any sort of exactitude to the harm that has been suffered by e-media, but it is clear when a party sets out to harm a competitor, this tribunal, with respect, should be slow to find that it has not done so. Finally, perhaps, given I'm not sure where I am on time, but perhaps if I can say this on exclusivity and efficiencies, which is at the heart of the Multichoice's answer. Multichoice appears to proceed from the premise that the fact that it is paid for exclusivity means that it's immune to competition law scrutiny. I've already dealt with the Premier League, the Nike and the Fila cases, which illustrate that that's not so. The Super League case, to which we refer now here, also makes that point. Closer to home, our courts have made it clear that exclusivity is not immune to competition law scrutiny in cases in the Concourt, in Pick and Pay, and through the retail sector cases dealing with exclusive lease agreements. There are many cases, there may be cases where exclusivity is justified, but there will be many others that are not. And this is one which, for reasons I've already explained, is not. Multichoice says, well, it's pro-competitive, this provision, because it allows, the provision allows it to differentiate its services from its content from other broadcasters and from other broadcasting services. But it's already made the content available on the SABC, and that content is available on Centec and on Starsat. So it's not truly differentiated content at all. It's also for the same reason, there's no longer any true exclusivity. So what they say, and they're obviously appreciating this difficulty, they say in their heads of argument, well, there's still some incremental benefit to it, multi-choice, an incremental exclusivity, if I can call it that. They've lost some of the exclusivity through the sublicense to the SABC, but they still want to retain some of it insofar as OpenView is concerned. We say that's illegitimate for the reasons I've already canvassed with reference to the cases that I've referred to. But it's also important to note that they provide no evidence as to what to quantify this apparent, the value of this apparent incremental exclusivity. They don't put up evidence that they'll lose subscribers or advertising revenue if they put the content on OpenView. They say they could have got more money from the SABC in its sublicense if the sublicense didn't contain the restriction, but you're not told how much more. Indeed, it's clear from the correspondence that that option was never even contemplated. But if, and this will be my last submission on this, penultimate submission on the question of exclusion, of efficiencies and justification. If this provision was born of a genuine concern that allowing this content onto OpenView would bring about substantial harm to MultiChoice and would undermine the rights that it had obtained, one would have expected that there would be an analysis, not carried out for purposes of the litigation. I'm not talking about an economic report or any of that sort. An analysis carried out at the time that the restriction was first imposed as to why it was necessary. That's what a rational and justifiable business would have done. But where you are imposing the restriction simply to harm your competitor, you don't do those analyses because you know why you are doing it. And we say the absence of any true business case for this restriction puts paid to this justification defense. It's really got nothing to do with protecting exclusivity or allowing MultiChoice to differentiate. They waved that goodbye when they granted the sublicense in the first place. They just opportunistically took the advantage of granting the sublicense to put the nail into OpenView. And that's what this case is about. I should also say, finally, that the whole justification defense runs contrary to MultiChoice's argument about SABC having universal coverage, because if it has universal coverage as they claim, what is the point of this restriction? Why insist on it? As I intimated at the start of my so if I can summarize then, exclusivity is not an appropriate justification in this case. The fact that MultiChoice has obtained exclusive rights does not entitle it to abuse that exclusivity to anti-competitive ends. Insofar as irreparable harm is concerned, I've outlined the harm to eMedia in the basic satellite market. That is the irreparable harm to its competitive position. On the balance of convenience, I've explained to you that there is in fact no harm which arises to MultiChoice on the facts of this case, and therefore the balance of convenience favours the grant of the interim interdict. I should note finally, we place no reliance for present purposes on the Section 4 argument. That is something that may be pursued in due course in the complaint referral and in the investigation by the Commission, but for present purposes, Chair, you need have no regard to that part of the case. Unless there's anything further, those are my submissions.
Yes, let me check if there are questions. Ms. Bizwan.
No, thank you.
Professor Vilakazi.
Thanks, Chair. Just a couple of quick ones. Mr. Marriott, and I'm sure you've kind of had a look, but in the MultiChoice heads at 126 of the confidential, so it's paragraph 105, they refer to certain statements by eMedia relating to the link between its revenues and growth and sporting content. And I'm sure you know the details, so I won't read it out in case it's confidential. And certain kind of remarks by eMedia itself in this regard, I think at the High Court. As a counter, essentially, to the kind of significance of this particular content, which around which you've also defined your market, around premium sports, etc. So can you square this kind of critique, I suppose, a response from MultiChoice up with your view that the kind of growth of eMedia or OpenView has thus been undermined, particularly as it relates to these rights, and particularly as it relates to these kind of two events that triggered the application?
Yeah, so what they said, I don't think it's correct. eMedia's sales of decoders did not increase year on year as a result of broadcasting this content. It is a separate inquiry, and that entirely, as to whether going forward into the future, as a result of the brand being harmed through this conduct, eMedia's goodwill being undermined, whether eMedia's growth will be stunted as a result of this conduct. In other words, we're not saying, well, if we have the Rugby World Cup if we'd had it in October, we would have sold more decoders. But what we are saying is that those who had already chosen to get an OpenView decoder, and those in the future who may be choosing between DSTV and OpenView, will be influenced by the fact that they know that if they get DSTV, they can get the sports content. If they get ETV, they can't because of this restriction. So it's about damage, and it's not about increasing sales in the short term. It's about damaging the brand and decreasing growth over the short to medium term.
Sure. And so really then, just to make sure I understand your earlier remarks, at the core of the harm direct to eMedia here, it is, as I think you repeat in your heads as well, this issue of reputation, goodwill, credibility harm, right? And in the eyes of the consumer. And then I think to support that, you referred to some of the emails that were sent to the BCCSA, etc., by consumers, which when I read them, seem like consumers complaining about the SABC, as I see it. Some of which say things like, the SABC has a responsibility to entertain us, I think is one of the quotes, etc., right? So I want to just square up what else can we take and have regard to around this kind of reputational harm. Is the first, just let me finish, please. And the second part is just to understand that your primary concern then at this point, and thus the application, is for upcoming events in the future as a result of the credibility and damage and loss of credibility. So that's arisen of these last two events, for instance.
Well, let me just
to square all of those things up, please.
Let me clarify first of all, consumer harm because Mr. du Plessis did, but that is the first point. You don't even have to get into competitor harm, because SAA says that if you find consumer harm, that's good enough under the rubric of anti-competitive effects. And with respect, we say the facts are self-evidently give rise to anti-competitive effects insofar as consumer harm is concerned. Insofar as competitor harm is concerned, you've got harm to the SABC, which I've dealt with. And then insofar as eMedia is concerned, these complaints are eMedia the first one says, you are advertising the Rugby World Cup games on OpenView SABC, but not airing or even showing any part of the games. You should be penalized for false advertising. So it's a complaint clearly against OpenView. And I'm just picking another 213. I'm a loyal payer of my TV license, and I have OVHD. How come we cannot watch the rugby matches of our very own country playing matches on OVHD? It's absolutely sad and disheartening. Whether they blame OpenView or not is not the question.
Is it not?
No. The question is, what is consumers' perception of the value of the SABC channel on OpenView as a result of this restriction? They're going to say, when I decide between DSTV and OpenView, I can get some sports content on SABC. So I can get a lot of sports content on the SABC channel that I get through a very basic satellite package on on DSTV. If I go for OVHD, OpenView, I don't get that sports content. The perception and in fact the reality created by this is that consumers have come to learn and understand that the SABC that they get on OVHD is not the same as the SABC that they get on DSTV. And that's the damage. And that's why it will impact. And it doesn't matter if they blame the OpenView or not. Those are that's the reality.
Sure.
It's an objective comparison.
Just lastly, Chair, I mean, so then on that point, my understanding is that some of the agreements relating to, say, for instance, the two events, the Rugby World Cup 2023 and the cricket as well, that kind of really trigger the urgency in the applications, were negotiated quite some time ago, as I understand it, at least 5 years ago, right? And my understanding, yes, that's right. And my understanding is that effectively, the pattern has been, as I think is claimed, that this restriction has been in place, the open view restriction has been in place in a number of prior contracts as well, right? So it's almost to some extent nothing new, at least for the last 5 years, right?
Well, at least
if thought about that way.
Yeah.
And so what has changed? What are we kind of urgently responding to here? If the consumers could never, I suppose the last time I think SABC was allowed to show the Rugby World Cup 2019 on its platform, what's changed between that world and now?
Well, I don't want to delve into the facts, but I think there was arrangements.
Oh, no, we must.
No, in facts that are not on the papers. Sorry, I apologize. But
sure,
the PSL issue. What spurred it was, of course, the 2019 Rugby World Cup. I don't want to speak about it. I'm not 100% sure of the facts, but I think they may have been different. That's all I will say. The 2020, what spurred it was, of course, the national interest in the Rugby World Cup, and following on its heels, the Cricket World Cup. Those are events which, and then the market conditions. OpenView is now a viable competitor to DSTV, at least in the basic satellite market. Can you say that in 2019? Analog switch off is now a reality. I guess that's what I want to really stress about all of this. This is happening, and the reason there is so much activity before this tribunal in this sector is because this is a critical time in the broadcasting sector. That's why you're seeing as much activity as you are. And the urgency is that what happens now during this critical time will perpetuate over many years to come. So it's about preventing Multichoice over the next 6 months, gaining further advantages through compelling the SABC to give us reruns of of old and frankly very boring matches, when in fact there's exciting content on every other SABC channel. That's what the urgency is about.
Thanks, Chair.
Sorry, if I can just give you a reference, Professor Vilakazi, it's page 52, paragraph 136.4. 36.4 deals with the 2019 World Cup issue.
Thanks. Mr. Marriott, if I can ask you to deal with the criticism against your Section 81D3 case, and specifically that it is alleged that there is no leveraging of market power in this case from one market to another. Can you just deal with that criticism from your perspective?
Yeah, I don't understand the argument. There is clear leveraging. They're leveraging the market power that they have in the content acquisition, premium sports broadcasting acquisition market. And I've explained why they are dominant in that market. And they're leveraging that power to obtain an advantage in the satellite market, and even in respect to the channel, even in respect to the SABC, they are leveraging that power in the channel provision market. But for my purposes, there is clear leveraging. I'm saying I've got all this power in relation to sport, and what I'm going to do is I'm going to leverage it to compel the SABC to give me an advantage in the satellite market.
And then finally, the relief that your client seeks. Can you respond to the SABC's comments on that relief, and specifically the SABC saying that they should not form part of any relief that is given in this case? Have you considered that, and are you revising your relief? What is your client's view about that?
So the relief that we seek is simply that the first to fourth respondents are interdicted from implementing and enforcing the restriction. I mean, frankly, it would make no difference. I hope I don't speak out of turn if that said first to third, because it is clearly only Multichoice that would seek to implement and enforce the restriction in the sub-licensing agreement. Insofar as the SABC is concerned about backlash from Multichoice, should, in any attempt to cancel the sub-license, well, firstly, I think that's a bit of a straw man, because they can't cancel the sub-license. They are compelled, nor can they refuse to enter into these sub-licenses in the future. They are invariably compelled to do so. And in any event, if they were to do so, to refuse to sub-license at all, that of course may give rise to another application before the tribunal. So I'll take an instruction, but as far as I understand, we have no difficulty with limiting the relief to Multichoice and Supersport.
Okay, you can clarify that for us after the lunch break. I just want to check the order in which council is going to present. Is it correct, Mr. Farlam? You are going next, followed by Mr. Trengo. Is that correct?
Yeah, yes, Chair, that's my understanding, yes. I think that's probably the right order anyway.
Yes, I just want to check that everyone's happy with that order. Mr. Trengo?
Certainly, sir.
Yes, okay. So let's take the lunch adjournment now. We will take a shorter lunch. Let's return at 1:45.
Ma,
Yeah.
my eyes were too big and greedy.
Let me check if everyone's back. Yes, we can continue. Mr. Marriott, did you want to say anything further
Yes,
about your client's
Chair,
relief?
Chair, we are content if the relief is limited to the first to third respondents, both 2.1 and 2.2 of the notice of mission.
Thank you for clarifying that. Mr. Farlam?
Thank you, Chair, and members of the Tribunal. Sorry, I'm losing my voice a bit, but I hope you can hear me. I've got half an hour, and I propose to address three topics. The first is to provide some background with relation to the effects on the SABC and SABC's concern about potentially prejudicial aspects of the relief. That's the first issue. The second issue I'd like to address briefly is the relevant market and Multichoice's dominance in the relevant markets. And then the third issue, which I'll touch on briefly at the end, is Multichoice's argument that it's not abusing its dominant position when acquiring and sublicensing free-to-air rights, FTA rights. And I'm going to address that in the context of the Rugby World Cup negotiations. As I mentioned earlier this morning, the SABC has tried to be a responsible respondent, and it agrees where appropriate, but doesn't really amplify. It disagrees where it considers that appropriate, and it has sought to set out helpful background information from its position as the national public broadcaster and as someone who can speak to the position of the customers, consumer welfare, and the public interest. And before I get to the three topics that I'll address, if I can then also just clarify, we disagreed with eMedia regarding its Section 4.1 attack, but that's now become academic. They've abandoned their argument that we are somehow guilty of restrictive horizontal practice. We also disagree that we should be the target of the attack, but it seems that also has become relatively academic. You don't get an interdict against someone who doesn't want to do the thing that you're complaining about and has never shown any intention of doing that. But that's eventually become academic, it seems, in the light of their indication of the relief they would be happy with. The third broad area of disagreement was concerning their allegations that we'd somehow breached the agreement with the second applicant, the Platco carriage agreement. That seems, though, to be immaterial for present purposes, so we can ignore it. And then before moving on, perhaps just to reassure Multichoice that we are trying to make responsible submissions rather than ganging up on them, I must correct something in eMedia's heads, which was then also echoed by Mr. du Plessis this morning. In page 18 and page 50, they attribute a statement to the SABC that's in fact their own statement. They say SABC explains that in broadcasting the SABC's channel to around quarters of the SABC's national audience, eMedia assists the SABC to fulfill the public right of access, etc. They give a reference at 521. It's in fact their own replying affidavit. The statement is correct. We don't disagree with it, but I just wish to clarify that we didn't actually say it ourselves. They've said it, and perhaps we could have said it because it's not incorrect, but we didn't say it. If I may then turn to the first of the topics that I said I would address, and that's the SABC's position and the reasons why it has concerns about the relief as currently sought. Now, the appropriate place to start is to note that the SABC itself filed a complaint with the Commission in July 2022 against Supersport. And that complaint is in the confidential bundle at 233 following, and we commend that to the tribunal. There's also a summary. It's a very brief and sort of incomplete summary, but it is somewhat helpful, and it's Annexure C to the founding affidavit 96 to 98. And what can be seen from that is that SABC considers there to be two relevant markets from its perspective. There is the upstream market, which is the market for the acquisition, whether from the original source or from a licensor, of premium sporting content. And then there's a downstream market for the broadcasting of premium sports content. And our submission is that MultiChoice is dominant in both markets. And as anybody who has any interest in sport in South Africa will know, that's hardly a starting proposition. And particularly importantly, we submit that MultiChoice leverages its market power in the upstream market in order to prejudice the SABC and advantage itself in the downstream market. And I come back to that when I'm talking about how they've dealt with their free-to-air rights, which they have locked up, and then how they deal with it with the SABC. And in our complaint, we also then, that's in paragraph 2 on Annex C, where we deal with the markets. Then we've also deal in paragraph 4 with the fact, and 4 and 5 is that the contract that was then at issue at the time of the complaint was our PSL contract, the PSL and the MTN8 rights. And that's again at the confidential bundle 157 following, and we commend that to the tribunal. The restriction there is even more onerous than in the later agreements. And what was particularly concerning for the SABC was that the SABC was not allowed to broadcast those soccer matches on its SABC sports channel. We all know about SABC 1, 2, and 3, but SABC had tried to introduce and has tried an SABC sports channel, and obviously it wanted its soccer on the sports channel to try and give that some publicity and some support, and it was not allowed to do that by the PSL agreement at the time. Things have now changed and they can, but so that was then part of that, the part of the complaint. And then if one turns over to the next page, one sees we alleged contravention of 81C and 81D2. Emedia haven't gone for 81D2, that's probably unique to the SABC, and section 5.1, that's 6 and 7. And then in paragraph 10 of that annexure, it's commented on the rugby matches. And we elaborate on that in our complaint, and we also then refer to it in our answering affidavit in these proceedings. And in Annexure A, at pages 294 and following, we can see an excerpt of the correspondence in that regard. And just by way of overview, what happened was that the SABC was desirous of sub-licensing rights to broadcast Springbok rugby test matches played in South Africa, and in particular the matches against the British and Irish Lions. And that was obviously going to be something of great public interest, the matches against the British and Irish Lions. I think they toured every 10 years or so. And as is apparent from the correspondence, one can see at 294 to 297, Annexure A of our answering affidavit, as well as our complaint, we were unable to get agreement on that because the MultiChoice insisted on a restriction. They say, it said delayed, but we will eventually be able to get over that. But they said it could only be on SABC 1, 2, and 3, and then they underlined and in bold, not on any other channel. So again, they wanted to block the SABC from broadcasting it on the SABC sports channel. And one doesn't need to be particularly astute to realize that the SABC sport channel would be a competition for the for Supersport's sports channels. So we give some real examples of how the SABC has been prejudiced and how the complaints have been and how they've tried to restrict. They've had the same restriction that's now been applied again. So that was our complaint in July 2022. It's still being investigated. There was also another aspect to the complaint, which I should just mention very briefly. It concerned the bundling of sports rights. So as we know, overseas in Europe, it seems that that's been declared anti-competitive and you can't bundle the free-to-air and pay TV rights together, but the South African Rugby Union does, and the PSL did. And as we can see, World Rugby and ICC do the same. And so we're also trying to attack that because we say that's part of the problem at the upstream level. But anyway, so that then was the complaint in 2022. Moving on then to 2023, the World Cup Rugby 2023, a Rugby World Cup came along. And as everyone will be aware from the news reports, the SABC was initially unable to secure any free-to-air broadcasting rights for that event. And then what happened was the Minister of Sport stepped in and 3 sponsors stepped in. And and then the SABC was finally able to conclude an agreement at the last minute. I think the tournament might already have started in order to broadcast games for that tournament. And I should mention that this is something I'm going to come back to. This was the Multichoice took the stance that effectively they weren't prepared to agree with SABC until the last minute, despite being obliged by World Cup Rugby to sublicense the free-to-air rights to a free-to-air broadcast in South Africa. That's apparent from the agreement, but that's also probably from the papers in the public domain. And as I will come back to that because we submit that's an important and egregious aspect. But in Annex E, on page 125, Annex E to the founding affidavit, you can see the statement that was issued by the SABC after getting the Rugby World Cup contract finally. And I will just read out a couple of sentences. SABC says, the agreement will unfortunately exclude OVHD e-media platform because of the restrictive conditions that Multichoice is placing on the sub-licensing agreement for the free-to-air rights for the Rugby World Cup 2023. This condition cuts off approximately 3.2 million South African households. The SABC regrets this irrational decision by Multichoice, especially in light of Minister Kodwa's emphasis that rugby plays a critical role in nation building and social cohesion. The SABC hopes in the interest of nation building and social cohesion, Multichoice will remove the restrictive condition to enable all South Africans to get behind the box. And then we'd like to thank our broadcast partners who managed to enable us to secure those rights. So we were very unhappy about the restriction, but we felt we could do nothing about that. E-media then approaches the SABC through its attorneys, and you can see that letter in Annex T to the founding papers. And that's at page 228 and following. And there they say, look, there's this restrictive condition. It affects us. It affects you. Won't you join with us in approaching the Competition Tribunal? Now, that would have been in the interest of the SABC, one would have thought. But as we explained in our answering affidavit, we were felt unable to do that. That's at 291, paragraph 60.3. We didn't feel able to join with them because we were concerned that Multichoice Supersport would seek to cancel our agreement in the face of that challenge. And we said then with calamitous consequences for the SABC, its sponsors, and many millions of South Africans who depend on the SABC to watch rugby. So despite the fact it would have been SABC's interests to try and get rid of the restriction about which they publicly complained, they did not feel able to do that. And we submit that speaks volumes about the market power and the state of the market. So e-media then went off to the High Court and they brought a common law competition anti-competitive argument. It was based on the Platco carriage agreement. We didn't agree with that, but that's beside the point. But what was then interesting was that our fears, the SABC's fears about how Multichoice would respond were realized because, as we know, Supersport Multichoice responded by bringing a counter application when they said, look, if you get that restriction removed from the sub-licensing agreement that you've concluded in respect to the Rugby World Cup, we want the whole agreement declared invalid because that clause can't be severed. So in the face of that, obviously, the SABC was very concerned. They described it in their papers as a callous decision, contrary to the national interest, but there it was. It obviously also then focused the SABC's mind on what would happen in that case. That case was then struck off the roll for lack of urgency. By this time, the Cricket World Cup, even for the 2023 Cricket World Cup, had been concluded. The Cricket World Cup had started. And as was, again, in the public domain, there was a similar restrictive condition in the Cricket World Cup contract. And in Annex F to the founding affidavit, we can see that the SABC complained about that as well. And again, they say the public can catch cricket on this thing. Multichoice has restricted the broadcast of the World Cup on the OVDH platform. The SABC has formally logged a complaint regarding this behavior and the SABC's approach to e-media, etc. So e-media then brought this application to the tribunal. They wanted to have it heard urgently before the Cricket World Cup was completed. The SABC did not agree to that, nor did Multichoice. and one doesn't, again, need to be a clairvoyant to understand what contract we were worried about having cancelled in that context. The Cricket World Cup is now over, but what we have still, as we know, is the PSL agreement, which has this very similar clause. We have coming up as well the ICC T20 Cricket World Cup, and the rights get bundled again. It's as we understand it, they would have the rights again. We would have to get a sub-license about that. So we are concerned, as we pointed out in our answering affidavit, that that Multichoice's response to the relief that is sought will be to say, well, the PSL agreement also falls because it's a not severable clause, and we would never have concluded it without that clause in it. And the reason why that's particularly serious for the SABC is we mentioned at page 271, 45.4. In respect of PSL games, it is noticeable the PSL competition regularly attracts large audiences of a particular demographic throughout the year. By way of example, the Supersport PSL channel, which is dedicated to broadcast PSL games in South Africa, has been the most watched sports channel in South Africa. In August 2021, it achieved a peak audience, etc. PSL is clearly a very popular offering in South Africa. We are worried that that is going to be cancelled by Multichoice. What is interesting is that Multichoice have put in a further affidavit, which has now been admitted. In that affidavit, they address our threat, their threat to cancel the Rugby World Cup contract in pages 33 to 35, paginated 33 to 35. And they should try and explain it, but what they don't say is in response to our answering affidavit, where we say there's no indication that they've changed their mind. Indications are they'll do the same thing again. They don't say, no, don't worry, we won't do that. So that's why we are concerned. eMedia, it doesn't seem to matter for them. They don't have the rights anyway, and well, they'll be no worse off. But the SABC clearly will be worse off if the Multichoice's response is to say, well, we are cancelling the PSL MTN soccer. At the moment, 20% of our audience can't watch it. It seems we think take 20, 25%, let's take 20. But still 80% can, and that will be quite significant if we can't broadcast that. So we make that observation. We don't know, in a sense, where that takes it for either of the parties, but we must voice that concern. There's a reason why we haven't gone before. There's clearly, we submit anti-competitive effects in the market and problems, but we don't want them to be made worse. So that by way then of background as to the first issue, some of the effects on SABC, as well as why it is concerned about how the relief could be counterproductive. Albeit that, of course, we acknowledge that we are harmed. Again, I must reiterate, SABC is harmed by the restriction. We've explained in our complaint why that is. I might just also then amplify. It's the advertising that would be for the broadcasting on OpenView. We would get the benefit. The SABC gets the benefit of the advertising on the OpenView. So the SABC has been deprived of that. And so the SABC, when they go out to advertisers, they've got to say, well, 80% of our market will be able to watch this. Obviously, that then affects the SABC's revenue. It also affects the SABC's reputation and brand as a broadcaster of sports. This is something that Multichoice Supersport are aware of. OpenView has complained about that, but we also say, look, people say, and I think Professor Vilakazi mentioned when they look at when the people didn't get them to see the thing on, they say, SABC, we thought you are a provider of rugby. Turns out you're not. So your reputation goes down. And of course, there is also harm to the consumers, the customers who can't watch it. So there's financial harm, there's reputational harm to the SABC, there's harm to the customers. But nevertheless, we are concerned about Multichoice making it worse. Mr. Marriott said, well, they can't do that because of sort of national broadcasting requirements, or if they would, they'd be back here again. That's sort of easy for eMedia to say, but the SABC is obviously much more cash-strapped. The SABC cannot be rushing off to court to try and enforce things. So while the current restriction causes the SABC harm, the SABC has to be careful. That's the first issue then. And I want to turn to the second issue that I said I would address, which is the relevant markets and Multichoice's dominance in it. Now, we have addressed that in our heads of argument as well as in our answering affidavit. And just to recap, we submit that the relevant market upstream is the market for the acquisition of premium sports content and the acquisition and sub-licensing, and then downstream market is the broadcasting of premium sports content. Now, we know that Multichoice says, no, there's no such thing as premium sports content. It's too vague. Multichoice also says it's all interchangeable. You can watch a soap. You can have a soap opera instead of a sporting event. There's the same view. You would have the same viewership, etc. You can swap them out. We submit that those arguments are wrong. And what we also wish to point out is that they have been rejected by ICASA. So you'll see very similar arguments presented to ICASA, and the document, it's a little long and repetitive, but I wish to highlight some important features to show how Multichoice have advanced effectively the same argument before ICASA, and ICASA rejected them. ICASA says there's a market for premium products, premium offerings, and they agree that sport is not substitutable with soap operas, for example. Before getting there, also just wish to mention something else we highlighted in our complaint. At Annexure Q to the founding affidavit at page 208 following, the Competition Commission issued a media statement. This was in regard to various complaints against Multichoice and Supersport that didn't seem to necessarily have a lot of meat to them, but and they weren't referred. But what the Commission stated was as following at page 208, and I just want to read out, we refer to this in our complaint, but it's helpful again to emphasize this. At page 208 in the third paragraph, they say that there's a potential market failure in the market owing to the following factors, among other: 1, the highly concentrated nature of the subscription television market; 2, high barriers to effectively enter the market and the inability of other existing firms to expand in the market; 3, a lack of credible alternative buyers for premium sports rights other than the incumbent Multichoice; 4, overly long and exclusive contracts between the incumbent Multichoice and some content suppliers; and 5, a lack of credible alternatives to which individual consumers could turn should they wish to switch away from the incumbent Multichoice. And that certainly is the SABC's experience as well. As I mentioned, let's go back to ICASA, because ICASA, when we refer to it in our complaint, we know it's a draft document. But in our complaint, if the tribunal wished to make a note, at 272 of the confidential bundle in a footnote 22, we point out that we submit that the further consultations are not really going to address this issue. The point is, in any event, these are ICASA's preliminary findings, and at this stage of the proceedings, we submit that they are relevant and important. It's an Annexure D, as I mentioned. Annexure D starts at 301 to our answering affidavit. And then at 303, 1.3.4, I'm going to read them quite quickly, some of these, because, as I say, it is a bit long and there are quite a few, and I would like to try and alert the tribunal to most of the relevant paragraphs. 1.3.4, central to market definition in the broadcasting and video on-demand sectors is whether all types of content are substitutable. Multichoice argues that the concept of premium content is obsolete, and that given market developments, there's no longer a distinction between premium content and other content. We know they say that here. Other stakeholders agree with the authority that differences can be observed across different types of content. The authority finds that views to attach particular value to different types of content, etc. By the same token, last in 1.3.5 at the end, by the same token, the authority finds certain live sporting events attract a lot of viewers. Therefore, the authority makes a distinction between premium and non-premium content. Then turning over to 305, 1.3.11, and the authority maintains its position not all content is substitutable. There's not a single market for content. The authority finds there's a difference between premium and non-premium content. 1.3.12, the authority opts to identify what it considers to be premium content on the basis of characteristics of premium content. 1.3.13, for purpose of this inquiry, the authority considers the following to be premium content: Hollywood premium movies, major live soccer matches, including Bafana, FIFA World Cup, PSL, etc., live rugby matches, etc. And then 1.3.14, third line, the authority defined upstream markets: 1, for the supply and acquisition of premium content for distribution in South Africa; 2, the supply and acquisition of non-premium content. 307, 5.7.4, the last 5 lines, they identify The Commission is of the view that a premium thing must have the following 5 features. Then 5.7.8, foot of the page, we again have the argument MultiChoice submits the so-called premium content as a must-have is well understood to be obsolete. But then 308, 5711, ETB disagrees, content premiums must have, etc. Support examples, each says it has not been able to replace viewership after since losing the UEFA Champions League. 309, 5.8.2, content can be characterized into 3 main areas: sport, entertainment, news. Sport has the strongest reputation for delivering large audiences and our numbers of subscribers for broadcasters and pay TV providers. It remains a premium product for which viewers are willing to pay a higher amount, and in return for paying that high amount, they expect a premium experience. Operators and channels have shown willingness to spend substantial amounts on this proven customer acquisition tool, etc. Then going through 3010, 58.3, distinction between premium and non-premium, etc., dealing with that. Then moving forward to 314 at the foot of the page, you can see this, the wholesale supply of film and sports channels form a separate market. 3.15, 5.15, 15.8, the authority is unable to find plausible the argument of a single homogeneous global content offering this distinction between premium and non-premium, etc. They say that again, 5.15.9. Then 316, 5.16.2, some of this Celsi submits, Casime will obscure the fact that MultiChoice is, as a matter of fact, dominant in the subscription television market and for premium content acquisition and distribution. 317, 5.16.4, limited number of buyers or broadcasters. Sports federations can sell rights. We know that. Small markets, MultiChoice dominant in that. 3.1.8, 318, 5.16.6, large volume of precedent supporting distinct markets for different types of content at the topmost level of the broadcasting supply chain. And then there's, again, the foot of that page, there's a criticism of the distinction. MultiChoice says the premium is vague, does not derive from analysis of competitive constraints, etc. If I can then turn, I'll try and wrap up here at 320, 5.17.2. There's the MultiChoice, again, MultiChoice's arguments, we know what they are. Then the authorities does not believe that all content is substitutable for the following reasons. First, as been previously indicated, broadcasters act to satisfy the preferences of their viewers. It would be a fallacy to assume that lovers of live soccer would all of a sudden be satisfied with watching a movie, a drama series, a reality show, or news. Broadcast Top 321, a broadcaster that airs such live matches is faced with a SSMIP, decides to purchase other content, and in the event that they do that, they would lose viewers. This explains the high demand for rights to live soccer matches despite the high cost of such rights, etc. Then there's an interesting thing on page 322 about how MultiChoice has gone on to acquire a lot of premium soccer rights. These are the most popular competitions. These are premium content, etc. And then going forward, if I can then ask the tribunal to look at 323 all the way through to 329. These are quite important things. Basically, what they're saying is sports rights are not substitutable for other kinds of rights. There's a premium market and there's a premium sports market, and you can see from the various broadcasters' behaviors as well as various decisions how they are not substitutable. And then just, for example, 327, the top of the page, for instance, live sports are not substitutable for movies in the authority's view, neither a series of local content. Viewers would not necessarily regard sport as a substitute to movies, etc. So we submit that. And then just one final thing, when one's dealing with it at page 331, Annex E, there's a table there of the various rights that MultiChoice has. MultiChoice has mentioned that it hasn't acquired various rights, some to tournaments that I frankly haven't heard of, but we know that the big events, the ones that actually have interest in South Africa, it has. And we note that, for example, in their answering affidavit, they say they don't have AFCON. They decided there is enough interest. They do have AFCON. They have the SA20. They have a lot of sporting events, and we've tried to assist the tribunal by giving an example of some of them. So that then is the market. We submit that MultiChoice is dominant in that market, and that also comes from the ICASA report, where they show that MultiChoice is focused on these sporting events, and they've obviously done that for a reason. It's a huge revenue driver. I want to wrap up then with the third topic that I said I would address, and that is MultiChoice's treatment of its FTA rights. Now, its argument is, we made the argument, well, you get FTA rights, even though you can't use them with the intention of prejudicing us. They come back and they say, no, these are bundled together. Now, the bundling is an issue that we've taken, that we be challenging, but we acknowledge that, for example, the Rugby World Cup did sell them bundled rights for pay TV and free to air. But the question then is, well, how did they react in that? Did they abuse their dominance in that market? There is that the upstream market for the acquisition of premium sports content. The SABC tries to compete in it, but it cannot remotely compete with MultiChoice. For example, the SABC could never have bought those rights for the Rugby World Cup and then tried to sub-license the pay TV rights to MultiChoice Supersport. It simply doesn't have the cash. So MultiChoice gets the rights. It then sub-licenses them or not to a public broadcaster like the SABC. But because they're competing in the downstream market, it is in the MultiChoice's interests to sub-license, the later the better, as far as their sub-licensing goes, because then obviously the amount of advertising revenue that can be secured and the product that the SABC can offer will be limited. It must also be as narrow as possible to try and get as few viewers of the SABC as possible. And then if there can be other restrictions, for example, delayed broadcasting or other things, that would also be in the interests of MultiChoice. Now, MultiChoice say in the answering affidavit at page 357, 358, they say they're dealing with the LBA, which was the licensed broadcaster agreement with Rugby World Cup and Supersport. And they say, 357, para 75, we were obliged in terms of clause 7.4 to act in good faith to protect commercial rights. In 76, they say, Rugby World Cup was aware SABC, South Africa's public broadcaster. It therefore supported Supersport concluding a sub-license agreement with the SABC in respect of the 2023 Rugby World Cup. But that is with respect misleading, because it's common cause that they were obliged to do so. And the agreement is in the confidential bundle, and the relevant clause is at page 7. I won't read out the clause, but it's the definition of permitted sub-licenses. And one sees there that there's an option and then there's an obligation. But it is in the public domain, it is in the publicly accessible affidavits, that there was an obligation on Supersport to sub-license to free-to-air broadcast in South Africa, obviously the SABC. And you will see it's in the just below the middle of the page, you'll see what their obligation was in relation to the number of matches, in relation to whether it's live or delayed, etc., etc. So it's not simply they say supported, they're actually obliged to. But what we point out is that we weren't told about that. And in fact, MultiChoice said to us, we can cancel and we will cancel your sub-license. And we first learned about that when the agreements were disclosed in their entirety in the High Court proceedings. And if the tribunal, what we also have is the sub-licensing agreement with Supersport and the SABC. That starts at page 55. And there's an annexure to that at page 76, which has extracts from the agreement. And you will see that the extract from the agreement starts at page 14. And the clause that imposed the obligation on the Supersport was at page 4. So it was left out. So we learned to, as our shock, that they, in fact, when they were saying that they could cancel the Rugby World Cup, our rights, they couldn't really, well, they couldn't without being in breach of their obligations. Then at 358 of the answering affidavit, they say, paragraph 80, SABC had previously had rights for the 2011-2015. Supersport elected to accept this amount with considerable concern, the amount that was offered, and a significant economic cost, but did so mindful of the SABC's financial position and in order to promote the free-to-air coverage to the licensed matches on the public broadcasting service. Now, we submit that in face of the MultiChoice's threat to cancel the contract, and in the face of the negotiations, that it's difficult really to take that with to read that with a straight face. It didn't seem to show any great interest for the national interest or for the SABC as a whole. And now, what is useful is to look at the negotiations. They were annexed, provided by Multichoice, and then annexed as Annexure G to the founding affidavit. They were then annexed again for some reason as Annexure AA5 to the answering affidavit. But I will just mention this to give an example then of how difficult it is for the SABC in the face of Multichoice's control of the rights and their position in the market. And what we can see at the first thing is at page 128, we can see a letter from the SABC, Mr. Plaikies, on 9 May 2023, and you can see he's asking for 24 live matches. You might want to correlate that or look back at the agreement from World Cup Rugby and see how that relates. And they want live matches, and they want the following things, etc. Then the response is on 132, that's on 7 June. So that's the formal response is a month later on the 7th of June, and they are prepared to counter-offer with the opening match, all matches, SA participates in 2 quarterfinals to be selected by Multichoice, 1 semi-final to be selected by Multichoice in the final. And in the complaint you'll have seen, we also complain about the fact that Multichoice chooses which games we get. And then at 135, we see again another counter-offer from the SABC for 24 matches, opening and closing, etc. At 139, we then get another counter offer from the SABC on the 18th. No, it's the 18th of August to 137. Now we're on the 21st of August. The tournament starts in September, and at 139 we see Mr. Plaikies says to Mark Jury, unfortunately the time is too short for the SABC to monetize this offer. In the interest of nation building, please consider providing the Springbok games to the SABC that our whole nation can support it. 141 we see Mark Jury's response is, we'll be able to offer you delayed broadcast, not live games. And then we see Mr. Plaikies saying, in fact, I'll just read this out and I'm about to wrap up. Mr. Plaikies is extremely disappointed, disingenuous to ignore the fact that Supersport has already locked up the sponsorship market around the property months ago, making it impossible for the SABC to adequately monetize the Rugby World Cup at this late stage. You further want to block the SABC Sports channel from the only other large platform of OVHD, further stifling the SABC to monetize this. This uncompetitive restriction has a further negative impact on our revenue, as we must displace our schedule and forgo the already guaranteed revenue on the current schedule. Our previous offer, therefore, based on fair value, etc. Finally, we'll see we're going forward. We'll see 143. We see again 143 in SA. It's now 31 August. SABC is prepared to accept your offer, but cannot accept the restricted conditions on a delayed basis. Finally, we know the negotiations collapsed, but then they finally, with the help of sponsors and the minister at 146, we come back and we get various rights. But it shows ultimately the SABC had to agree to this restriction, even though this restriction cost 20% of its viewers, 3.2 million. And it did so at a time when the tournament was about to begin, when obviously its ability to put together a premium product and to get other sponsors was significantly compromised. So that then is an example we submit of the effect, actually effect in the market, the effect of this condition and how Multichoice acts in the market. To wrap up, finally, we didn't bring this application, but we considered it helpful to put information before this tribunal. We asked the tribunal to consider the potentially prejudicial effects, and as well as the anti-competitive behavior that we submit that we have adduced before the tribunal. Thank you, Chair. That's our submissions.
Thank you, Mr. Farlam. Let me check if my colleagues have questions. Professor Lekazi.
Just one, Chair. Mr. Farlam, thank you. Just a distinction, to understand the distinction that you made a bit earlier, and you mentioned the ratio between or a number in terms of the proportion of your clients that would otherwise, or the SABC's clients that would view the SABC channels on OpenView relative to through mostly the SABC's own channels. If you're able to say at a high level, I'm not sure if it's confidential, but is there a significant difference qualitatively in terms of the different channels? So this, because as I understood it, the number you mentioned in terms of those that watch on SABC's own channels and mediums, it's quite a high proportion, right? Of clients that still had access.
Yes, I think 80%.
Is there any other kind of substantive difference between the kind of, you know, what the experience of the customer is on that on OpenView versus directly through SABC? And I understand also that this would include SABC Plus, I think it is.
Yes, I don't understand there to be. I think, as I'm understanding the question and the position correctly, SABC, the channel that you could watch SABC2 on, whether it was on DSTV or through Starsat or through some SABC or through streaming or something, would be the same. The OpenView, then, you, instead of getting, that would be where to be different when it comes to the restriction. Instead of then getting the rugby match, you get some previous Currie Cup game. So that's the distinction, and that's 20%. I think, I don't think this is confidential.
Sure.
It's not. That 20% of the people of our viewers, we say, I think they said 16%, and some e-media said higher, but we thought it was about 20. We say 20, 25. They said 20. So it's about a fifth of the people would think that they were going to get SABC2 and be able to watch the rugby, and then be disappointed when they were watching the Western Province play the Bulls.
Sure. But then part of my, as I understand it, at least Multichoice's argument is that, well, even though perhaps those clients wouldn't have been able to, those viewers of SABC wouldn't have been able to watch on OpenView in that instance, they could still access the content anyway under the FTA and kind of access to the website and all of that.
Yes.
How do we square these up?
No, if that's right. I mean, if they, but they could, in theory, if they had Wi-Fi, good internet, they could watch it in that way. But as far as we're aware, there's quite a limited group of people. We're talking about people who are not able to, afford the DSTV package. They don't necessarily have fast Wi-Fi. But yes, there are other ways potentially to watch it. I think that does, of course, go back to e-media's point that, well, if it's so insignificant, well, what's the reason for the restraint?
Sure.
But in theory, there are other ways to do it. I mean, you can go to a friend. But yes, it's the reality is it's a restriction that's meant to bite, I think, and it does because those people don't have other access.
Understood. Thanks, Chair.
Thank you, Ms. Mzwai.
I'm covered. Thank you.
Mr. Farlam, just two questions from my side. You said in the EU one cannot buy pay TV and free-for-air rights as a bundle. Is that just the practice there, or is there something that prevents that?
Yeah,
from
we
happening?
understand. We understand that there was a decision, and it's set out in our complaint that it was challenged, and it was said that you couldn't bundle it. But if I'm wrong, I will make a submission. But my understanding was that was in our complaint we set out there's an EU case, and that was what has caused that to be the case.
Yes. Is it a competition case?
My understanding was yes, but
Yes.
if I'm wrong, I'll come back to you. I'll come back to you on that. I don't have a team of 4 juniors, so I'm by myself. But I was involved with the complaint, so that was. But my understanding was yes, and perhaps if I can then just reflect on that, and if I've got anything more helpful to add, I'll come back. But my understanding was yes, it was a directive rather than a voluntary choice of anybody.
Yes. If you can tell us what that case is.
Yes.
When you've looked into it, and then just on the amended relief of the applicant, do you have any comments on that now that they've excluded your client from the relief?
Yes, no. So we've always said that there's no base for including us, so that we think that would be appropriate. There is still the question of, well, what about MultiChoice turning around and saying, well, yes, okay, well, in that case, nobody's getting any sub-licensing rights. There's still that concern. We proposed a formulation to address that. They haven't taken it up. So we say that's unfortunate, but that's the way it is. But the other amended relief we think is probably appropriate, yes.
Okay. Thank you, Mr. Fowler. Mr. Trencove?
I shall address limited aspects of our case, 3 topics. Firstly, address some 5 issues of fact. Secondly, Mr. du Plessis' constitutional lens. And then thirdly, the 3 complaints of abuses of dominance. My learned friend, Mr. Cockrell, will then do the remainder of our argument, and where I get it wrong, he'll correct me. Can I start with the important facts? There are 5 of them. You can call them the big 5. And let me just emphasize, these facts are not controversial, but they are facts which we submit with respect seems to be forgotten in the debates advanced by e-media and the SABC. So let me just recite them and emphasize them because they must be borne in mind. The first topic is the quality and cost of broadcasts of sports events, international sports events. They are very popular, they are generally valuable, and they are, for that reason, generally very expensive. The rights to those broadcasts vest in the organizers of the events. They are intellectual property protected rights, mostly copyright, as my learned friend, Mr. Marriott said this morning. So we're talking about copyright protected rights, which are very valuable and very expensive. The broadcasters throughout the world compete for those rights, and there is generally open competition. There's no complaint before you today that the other parties before you do not have complete freedom to compete, whether individually or by clubbing together to compete for those rights in one form or another. They invariably leave it to Multichoice to acquire all these rights, to Supersport to acquire these rights, and then contend for sub-licenses. The second fact, the second issue is this, that it is inherent to Multichoice's business model that it has to differentiate itself from the services provided by the free-to-air competitors in order to make a business case. It sells subscriptions at a price so that it can only survive if and to the extent that it persuades viewers that it is worth to pay for their service rather than simply to be content with the TV they get free from the free-to-air broadcasters. So differentiation is critical to my client's very existence and is critical to the very basis on which it competes with the free-to-air broadcasters. They have the advantage that they can woo viewers on price. My client doesn't have that advantage. It invariably has to charge a significantly higher subscription fee in order to make a business case, so that the business model depends on its capacity to differentiate, to provide an enhanced quality product to the consumers for which they are prepared to pay a premium. The third is that exclusivity is essential for that differentiation. And my client makes it clear that the exclusivity of these rights is critically important. They say the rights lose about 80% of their value once you lose exclusivity. As a matter of fact, the Multichoice Supersport is sometimes obliged to sub-license to SABC, sometimes in terms of Section 60 of the Electronic Communications Act, and sometimes in terms of a stipulation in its own license. But it is never obliged to do so for free. It can merely be required to sub-license at a fair arm's length price. And then our opponents suggest that once there is a sub-license to SABC, all exclusivity is practically gone. But that is not so. Remember, the purpose of exclusivity is to differentiate between our product and those of our competitors. The sub-license to SABC may well destroy the differentiation between Supersport and SABC, but not between Supersport and the rest of the broadcasters in the market, and particularly not ETV. There is still a value of differentiation left for as long as it is not obliged to provide the sub-licenses to all its competitors in the market. But once it is obliged, or once it effectively is obliged to surrender these rights to all its competitors, its differentiation value is lost. In the fourth place, eMedia is before you claiming that it is entitled to have these rights for free in promoting its competition with the Multichoice. It does not compete for the sports broadcast rights at all. It spends no money on them. It makes no investment. It takes no risk. It seeks to invoke competition law in order to allow it free of charge to compete more effectively with Multichoice by obliterating the differentiation between our product and their product. They say that they require these rights in order, because if they were not afforded these rights, consumers might prefer Multichoice and SABC's broadcasts over theirs because they do not carry these live sports broadcasts. Well, that is what competition is about. My client invests heavily, assumes big risks in order to differentiate. And that is precisely what competition requires it to do, to provide an enhanced product to the consumer in order to persuade them to subscribe to its service. And then the fifth issue of fact is the counterfactual. If eMedia succeeds, Multichoice will not continue to subsidize eMedia. It makes it quite clear that it simply does not make any commercial sense for it to continue to pay these high prices for these broadcasts if it doesn't derive any differentiation value from them. So what it will invariably have to do is firstly to require of the SABC to pay a higher price, which has regard to the broadcast not only on the SABC platforms, but is a price paid for broadcasts also on the ETV, on the eMedia platforms. Or if it is unable to exact a higher price from the SABC, then it will simply not be economically feasible for it to acquire these rights. It will make a lower bid for them to the international organizers of these events. But if its lower bid does not do the trick, then South Africa will be deprived of these rights. What it will not do and cannot commercially be required to do, is to subsidize eMedia by providing these very valuable services to them effectively free of charge. Let me turn to my learned friend, Mr. Du Plessis' constitutional argument. He made a very passionate argument under the Constitution. But with respect, a more dispassionate analysis of the argument reveals that there is no substance to it at all. The constitutional argument stands on 4 pillars. The first is that their contention that the public has a constitutional right to live sports broadcasts. That is the starting point. And they say under the Section 16 right to receive information. So despite the fact that these are copyright protected sports broadcasts, they say the Constitution entitles the public to live broadcasts. Secondly, they say the duty to provide it to the public is not merely a duty on the state, but also extends to private parties. That is why it contends that Multichoice is under a duty to satisfy that public constitutional right. So private parties are under a duty. In the third place, the third pillar of the argument is that Multichoice is in breach of that obligation under the Constitution. Not eMedia, who has not spent a penny on it, but Multichoice, who has been the driver behind most of the international sports scene in South Africa. Multichoice is the constitutional villain. And then in the fourth place, the remedy for Multichoice's constitutional breach is in effect to force it to provide these sports broadcasts to its competitor, eMedia, free of charge. Now, we submit with respect that each one of those 4 propositions is fundamentally flawed. Firstly, the public do not have a constitutional right to copyright protected sports broadcasts, in the same way that they do not have a right to receive all books, all movies, all sports broadcasts, all TV series. Those are all copyright protected materials, much desired in society, high prices paid for them. But to suggest that the public are entitled to all information free of charge, even when the information is intellectual property protected, is simply unfounded. There is no such constitutional right to see the movie Barbie at free of charge. Secondly, if there is a duty to provide all information to the public free of charge, then it's a duty on the state. There is nothing in the Constitution to suggest that that duty is one imposed on private parties. In fact, it would be quite absurd to suggest that the Constitution requires all private parties to provide all information to the public free of charge, even if the information is copyright protected. And even if there were a duty on the on private parties to satisfy that constitutional right, who would be subject to that duty? They've only identified Multichoice as being a party under that duty. But what about eMedia? What have they done to satisfy that duty? What about the Netflixes and Amazons of this world, the streaming services? The suggestion that all of them have a duty to the public to provide them free of charge with copyright protected material is simply unsustainable. Thirdly, if there is a duty on private parties, then why is it suggested that Supersport is in breach of the duty? Nobody has done more to bring international sports broadcasts to the South African public than Supersport has done. And if there is some duty on the private parties to bring those that information, those broadcasts to the public, then Supersport has been a super performer, has been the only one who has effectively and massively been responsible for making the investments and taking the risks to bring international sports to South Africa. E-media has, in the context of this debate, done nothing at all. It has made no contribution on its own version. It is in grievous breach of a constitutional duty, because if there is such a duty on the private sector, it has certainly not spent a penny or lifted a finger to satisfy that duty. In the last place, fourthly, even if there is a breach by Supersport, Multichoice, why is the remedy for the breach that it should be ordered to provide these materials to e-media free of charge? If e-media itself is under a constitutional duty, which it has not done anything to satisfy, why on earth would the remedy for the breach be, in effect, an order compelling Multichoice to share its valuable rights with its competitor free of charge? So we submit with respect that the Constitution has nothing to say about this case. And the suggestion that there is a constitutional bias in favor of the e-media case is, with respect, not correct. If I may then turn to the abuse of dominance case, I will in the first place assume both market definition and dominance, and will not address those topics. If you have any questions about those topics, my learned friend, Mr. Cockrell, has prepared on them and will say as much about them as his time might allow. But I will move on to the three breaches for which they contend under Section 18. And the first is the breach of Section 81D1, addressed in our heads of argument in paragraphs 84 to 90. And if I may just go back to 81D1, the critical part of it prohibits in the following words. It prohibits any firm from, quote, forcing a buyer to accept a condition unrelated to the object of a contract. That's a part of the prohibition on which the case against us is based. Now, the multi-choice sub-licenses to the SABC limit the rights to use the copyright material granted to them to specific purposes, in this case, to broadcast on their own platforms and not on any other platform. But it is a common feature of all copyright licenses that the purpose for which the copyright material may be used is circumscribed. My learned friend referred this morning to broadcast in Gauteng and not in the Western Cape, or to broadcast live or after the event, or to broadcast on a certain platform and not on another platform. The restriction of the rights granted under copyright sub-licenses is a common and inherent and necessary part of it. It's a definition of the rights granted. And that is so in this case. You'll see from the definition of the example given in this case was the Rugby World Cup license, sub-license, multi-choice Supersport granted to SABC, quoted at page 12 of the papers. It is a long condition which describes in various ways and circumscribes the purposes for which the rights are granted. And the important one here is that it is granted only for broadcast on the SABC's platform. It is not a license. It is not an open-ended license with some open view restriction. It is a license to broadcast on a particular platform, and a license to broadcast only live, only once. Those are all inherent parts of the description of the license. It is not a clause which is tacked onto a product sold to force a buyer to accept a condition unrelated to the object of the contract. It is an inherent part of the definition of the right granted that the right is granted to broadcast only for a very specific purpose. So the requirement of Section 8, or the prohibition of Section 8, is limited to a term forcing a buyer to accept a condition unrelated to the object of the contract. This is not unrelated to the object of the contract. This is part and parcel of the very definition of the murks, of the subject matter of the contract. And therefore there is no breach of Section 8.1(d)(1). I may turn to 8.1(d)(2). Now, my learned friend, Mr. Marriott, did not display much enthusiasm for this complaint, and he didn't address it at all until the chair asked him about it. But the prohibition under 8.1(d)(3) is addressed in our heads of argument in paragraphs 91 to 99. This is the one inducing or forcing a buyer to accept a condition. The previous prohibition was prohibiting a supplier from dealing with a competitor. I apologize. The submissions I've made to you are apropos to sub 3. The case built on sub 2 is that the condition precludes e-media from dealing from SABC dealing with e-media. But with respect, that is also not correct. The condition, the right granted to the SABC is merely a limited right to broadcast once on a particular platform. It does not preclude SABC from dealing with e-media in any other way. And there is certainly no restriction on it to do business with e-media in whatever way they wish. And in fact, it is significant that the restriction we're now talking about predates the carriage agreement between e-media and SABC. It was triggered by an event where the SABC made material sub-license to it available to Telkom, and that triggered the introduction of this clause as a standard clause in the contracts with SABC. And all it does is to make clear that the party's intention is merely to license a limited product and not to license anything broader than that. It doesn't otherwise restrict or confine e-media in its dealings with the SABC. The third complaint is the one under 8.1(c), and that is addressed in our heads of argument in paragraphs 100 to 110, which prohibits an exclusionary act. The definition of an exclusionary act means an act that impedes or prevents a firm from entering into, participating, or expanding within the market. Now, e-media says in its founding affidavit, at page 65, in paragraph 181, it identifies the what it says is the restriction imposed on it by this provision. It says that it is impeded in its ability to participate effectively as a platform provider. Now, but that with respect does not make sense, because it complains that its complaint is that the SABC's broadcasts on its own platforms are reduced when rebroadcast, when carried on the e-media broadcasts, in that the same sports content is not carried on the e-media platform. But that says nothing about the platform, the capacity of the platform to act as a platform, to provide a platform to broadcasters. Its performance as a platform provider is not in any way impaired by the fact that its client, the SABC, chooses to broadcast a different version of its service on the platform. It says nothing about the effectiveness of the platform. So as a platform provider, the provision does not detract from the status of e-media at all. But insofar as what it does, and we accept, is that it, of course, may impair the popularity and therefore the goodwill of the e-media platform. But that is what competition does. That is the purpose of differentiation. That is the foundation of the multi-choice business model, is to differentiate it from its competitors by providing an enhanced premium product on its platform, which its competitors do not match. So merely to suggest that it renders the e-media platform less popular and therefore detracts from its goodwill is not to say that this is not a form of legitimate and in fact necessary competition. It becomes so only if the Exclusionary Act impedes or prevents the firm from entering into, participating or expanding within the market. And that's where Professor Vilakazi's questions to my learned friend comes in. The fact of the matter is that MultiChoice describes in its answer the fact that e-media has not satisfied this requirement. At page 370 in paragraph 133, makes 2 points. Firstly, that the set-top box activations have grown. This is now e-media set-top box activations have grown between 2019 and 2023 by compound growth of 19% per annum. Secondly, its advertising revenue has, over the same period of 2019 to 2023, quadrupled in value, so that there is absolutely no evidence to the effect that e-media is impeded or prevented from participating in or expanding within the market. It may be true that it sometimes does not succeed in matching the quality of the Supersport product, but that is what competition is about. That does not suggest that it is so inhibited in its competition that it is unable to expand within the market. It has successfully expanded within the market and still does so. There is lastly an issue raised by e-media and briefly mentioned by our learned friends, suggesting that whereas we seek to protect and enforce exclusivity, exclusivity does not enjoy any standing or protection in our law. But with respect, that is simply not so. This case, one must bear in mind, this case is about copyright protected broadcasting rights. The very essence of copyright is the legal protection of exclusivity. That is the whole foundation upon which copyright is built. It's protected internationally under the Berne Convention. It's protected locally under the South African Copyright Act, that's Act 98 of 1978, so that the default rule, the foundation on which these broadcast rights are created, marketed, and sold is exclusivity. So for our learned friends to say that our courts have not protected exclusivity in the lease agreements of supermarkets, supermarkets in shopping centers, or in the organization of international sports events, misses the point. The point is that this case is about the licensing and sub-licensing of exclusive rights, i.e. Copyright, so that copyright is legitimately protected precisely because it is in the first place of the essence of copyright that it affords a right to exclusivity. We do not mean by that copyright can't be misused and that the abuse of copyright can't be subject to competition law control. Not at all. We accept that that is so. But for our learned friends to make a more fundamental point that our law is disinclined to protect exclusivity as a general rule, that is simply not so. In this particular field, the starting point is exclusivity, unless it is abused in breach of the rules of the Competition Act. Thank you, Chair. Those are my submissions, unless you have further questions for me.
Let me check if my colleagues have any questions for you. Ms. Mzwai?
Provide any live broadcast services. It lies with the state. And the question is, in the context of this case and Multichoice being a private party, and the CAC decision in the previous e-media Multichoice case, where the CAC has required that we consider also the historical context, and in particular the fact of state aid previously in respect of Multichoice. What do you say about that duty given the state aid previously that is a factor historically that we ought to consider?
Well, as I remember, those comments were made in the context of the constitutional requirement for affirmative action. And in that context, certainly, insofar as the parties before the court may raise that consideration, it is a consideration that the courts need to take into account in interpreting the Competition Act and in applying it. I didn't understand that issue to be the one that my learned friend, Mr. Du Plessis, advanced this morning. He founded his constitutional argument on a constitutional right to receive information. And with respect, there is nothing to be said for the proposition that there is such a right, or that if there is one, that the duty to satisfy the right is imposed on private parties.
All right, we'll hear Mr. Du Plessis in reply then on that.
Thank
Thank
you.
you.
Ms. Mazai.
Just to follow up on my colleague's question, is there then such a duty on the SABC, and does the conduct of Multichoice not affect the duty of the SABC then as the public broadcaster?
Well, let me say it is hard to debate these issues because we submit that the argument is flawed at its origin. There is no public constitutional, there's no constitutional right vested in every member of the public to free sports broadcasts. And so it becomes complicated then to argue at the second or third level on the assumption that there is such a constitutional right. The question then is, who bears the corresponding duty to provide those broadcasts? But Chair, we submit with respect that if there is such a right at all, then the duty is one imposed on the state, and then it is for the state to do whatever is required to provide those those broadcasts to the public. It has not said that the contract in this case is in breach of that duty or that right at all. It made a contract with Supersport. Supersport adheres to that contract, and the Supersport has said that I gave you a sub-license, but also at the economy rate, at the price appropriate for the circumstances. So there's no complaint that SABC should have been afforded greater rights and that Supersport refused to grant it. Not at all. The debate between them was a debate about price, and the ultimate compromise was reached only when the SABC was enabled to pay a price acceptable to Multichoice.
Yeah, I understood from the arguments that were made that the option was never given to the SABC, so it was never on the table. So the issue of the higher price was never an issue that was on the table, and that it was the starting point is that exclusion in the contract. Want to comment on?
Yes, well, that would be so only if you can say that there is a constitutional duty on Supersport to enable the state to discharge its obligation. I mean, the state, if it really has a constitutional duty, then it can go to the organizers of these events and make contracts with them. There is no reason to suppose that even if the SABC is under a constitutional duty to provide free sports broadcasts to the public, that there is a corresponding constitutional duty on Supersport to enable it to do so. Or even if there is, then the same duty vests in eMedia. If Supersport has already walked 80% of the way in providing those rights, those broadcasts to the public, why shouldn't one require eMedia and the SABC to walk the last 20% of the way?
Professor Vilakazi, any questions from your side?
Yeah, just briefly, Chair. Mr. Trengov, just with respect to the agreement that we referred to earlier, I think by Mr. Falem, between Rugby World Cup Limited and Multichoice, right? And you spoke specifically about page 7, which sets out the kind of broad description of how of permitted sub-licensing. Just to understand how this works, in terms of the, so I've come to understand that the content provider, say the Rugby World Cup Limited company, will kind of at offer stage essentially determine that the rights are being sold as a package or a bundle with free-to-air rights as well or not, etc. And I think I've understood Multichoice to be saying in most instances, you have to take what they offer. If they want you to, if the price is for both FTA and pay TV rights, then you buy that, right? And so there's a relative kind of level of obligation where Multichoice is then required to sub-license, etc. in this case. Once Multichoice has acquired the right, what I'm trying to understand is whether it is then at kind of almost complete liberty to determine the commercial terms on which it then licenses on to the SABC or the free-to-air broadcaster. Now, this is aside from the kind of, I think what it says in this clause, which is that, you know, things around branding, etc., etc. Rugby World Cup Limited says it must look the same, etc., even for the sub-licensee. But I'm now thinking here about, for instance, the issue of price, to which that SABC has to pay for the rights, but also, I suppose, the kind of conditions that can go with the sub-license, including the one that's the subject of this matter, which is this obligation, this open view condition, right? Are those all Multichoice's choices, or are they in some way related to the original license with the Rugby World Cup Limited?
Well, the original license requires it to sub-license to a free-to-air broadcaster.
Yes.
But it leaves it open to Supersport to determine the terms and price on which it does so. The starting point is that the contract between the organizers and Supersport is a contract between the two of them, which doesn't vest any rights in anybody else.
Mm.
And all that contract says is that you must sub-license the free-to-air rights. And it goes on to say, but that sub-license is subject to my approval.
Yeah.
So the arrangement is go out there, see what you can do, and if you strike a deal, come back to me for my approval. So that is purely an arrangement between the two of them. It doesn't vest any rights in anybody else. And I would suggest that it means at least that Supersport is entitled to do an arm's length deal with a free-to-air broadcaster. In other words, a deal at normal arm's length terms and price. In this case, we know that Supersport says that the price was an economy class price precisely because the restriction was built in. If the restriction wasn't there, the price would have been significantly higher. So in the event, the parties were able to agree on price only because the package was confined.
Sure. And so, if I'm understanding you correctly, essentially the commercial decisions around some of the terms and conditions of the sub-license agreement really ultimately vest with Supersport or Multichoice.
Yes.
And the negotiation, as you said, an arm's length basis that it has with the SABC or anyone else for that matter.
Yeah.
Understood.
And,
Thanks, Chair.
thank you, Chair.
Yes, I think let's take a short break before we hear from Mr. Cockle and come back at 3:30. everyone's back, if they can just switch on their cameras briefly. Yes, there we go. Mr. Cockrell?
Thank you, Chair. Chair, my learned friend, Mr. Trengove, has covered a lot of the material. I'm going to do the best I can to avoid repeating what he said. There will be a limited amount of overlap. Chair, I thought what I would do for you and the members of your tribunal is to do something that hasn't been done yet, which is to give you something of a roadmap regarding what it is that you would have to do when you reserve your judgment and when you go away and write your award. Because you've heard a lot today about various sections of the Competition Act, you've heard a lot about the Constitution, but what hasn't been presented to you in a systematic way is what it is that you will have to do when you consider what your decision is going to be in this matter. And so let me start with some very basic propositions, if I may. The source of your power to give the interim relief that e-media is asking for is section 49C of the Act. So those are the tram lines in which this tribunal operates when it decides what to do. With respect, the starting point, the tram lines are not given by the Constitution. The Constitution sits at the top level of our legal order, no debate about that, but it's mediated by the Competition Act. So the starting point for you is section 49C. And what you'll see when you go to section 49C are provisions that are well known to you. The power to give an interim order depends on whether it would be reasonable and just to do so, and you're required to have regard to the following non-exhaustive list of considerations. Number one, is there a prohibited practice on at least a prima facie basis? Number two, will the interdict, is it necessary to prevent irreparable harm to the applicant? Chair, I need to emphasize that because that, with respect, is where you should be starting when you go away and consider what to do in this case. It is not the case that those requirements in section 49C can be short-circuited by going directly to the Constitution. I need to emphasize that because part of the immediate case, certainly from our learned friend Mr. Du Plessis, appeared to suggest, at least at some places, that you go directly to the Constitution in deciding whether interim relief should be granted. But that is not correct with respect. And the tribunal dealt with that very issue in its decision from end of last year. It's Apollo versus Auditex. It's referred to in our heads, Apollo versus Auditex. And one of the issues in that case was, what does the tribunal do in an application for interim relief, having regard to Mediclinic, the judgment of the Constitutional Court, and other CAC decisions dealing with transformation and other transformative criteria? And what Auditex said, what this tribunal said in paragraph 47 is, interim relief cannot be granted in the absence of, I'm going to quote, clear, non-speculative and uncontroversial facts. Clear, non-controversial and non-speculative facts. So with respect, if that is not the case, if those facts are not before you, then no attempt to have regard to the Constitution is going to take away the fact that there is no substratum before you. There is no basis to give interim relief. Now, I need to emphasize that, Chair, because when my learned friend Mr. Du Plessis was asked 40 minutes into his address, when the Competition Act had not received a single mention, when he was asked what is the basis in the Competition Act for the various submissions he'd made, his answer appeared to be, well, it's all of the requirements in section 49C. But my learned friend Mr. Marriott took a different view when he argued the case. He said most of those considerations would be relevant to the second requirement, which is, would there be irreparable harm in the absence of interim relief? And as we understand it, that's the basis on which my learned friend Mr. Du Plessis was seeking to imply that there was constitutional harm, harm to consumer welfare, because of the deprivation of some or other constitutional right if interim relief were not to be granted. Let me deal very quickly, if I may, with that constitutional argument. I'm going to make 5 submissions in that regard. The first is the one that my learned friend Mr. Trengove has made this afternoon. There is nothing in the Constitution that guarantees any South African citizen a right to watch the final of the Rugby World Cup or the final of the FIFA Soccer World Cup on live television. It's simply not there. That's the first point. The second point is the Constitution, in fact, contains rights which go directly against that. The most obvious one is the property right. When my client Multichoice invests millions of rands to acquire the broadcasting right, those rights become the property of Multichoice. Sometimes property can be taken away from the person in whom the right is vested. Sometimes a person can be deprived of property. But with respect, it certainly can't happen in the current context. There is nothing in Section 49C to suggest that the constitutional protection simply falls away in the current context. The third point to make, Chair, is one I'm going to come back and make time and time again this afternoon. The counterfactual of e-media and of Mr. du Plessis is entirely wrong. The counterfactual that they ask you to consider time and time again is they say, well, you have a sub-license agreement between Multichoice and the SABC. It contains what they call the open view restriction. You must just tip-X out that open view restriction, in which case the 20% of the population who they say are not able to watch the final of the Rugby World Cup on open view would now be able to watch it. But with respect, that's not the case. The correct counterfactual is if the open view restriction was not there, then it becomes a point of contestation whether the SABC would ever acquire a sub-license at all. And you know the reasons for that. My client says on affidavit, if the open view restriction did not exist, they would require a much greater payment from the SABC, and that may be too rich for the SAB's blood. Or alternatively, it may no longer be in my client's interest to acquire the rights from the owner of the rights, FIFA or Rugby World Cup or whoever it is. So it's far too facile, it's far too simplistic for e-media to create the simple universe in which you posit the current world with the open view restriction and an alternative world in which everyone can watch open view without the open view restriction. That is not the correct comparison. The fourth point I want to make about the constitutional scheme is it entirely ignores the economics of how these broadcasting events are funded. In fact, with respect to our learned friends, it shows a quite breathtaking disregard of how it is that these events are ultimately broadcast. You know the story. The organizer of the event, FIFA Rugby World Cup, whoever has the rights, they have exclusive rights. They decide who they're going to give those rights to. There's a payment for that. Sometimes there is then a sub-license for which a payment is made. But each of those payments is following a market mechanism. And so when our learned friends say this is a public good, with respect, that is not normally the way in which public goods are funded. They could be funded in that way, but public goods such as roads or parks are not funded in that way. And with respect, the reference to public goods is entirely helpful in this context, where everything is turning on payment through a series of market mechanisms. And the fifth point I want to make about the constitutional argument is it's of no help to e-media when it comes to dealing with the first requirement for interim relief, which is have they shown a prohibited practice, at least on a prima facie basis. They have to show that. The jurisprudence of this tribunal shows that if they can't establish that, all the other requirements fall away. And it's of no assistance to talk about a constitutional prism or a constitutional lens or any of these other metaphors when it comes to getting out of the starting blocks for e-media and showing that my client has engaged in a prohibited practice on a prima facie basis. That is the first task for them, and the constitutional prism is not going to assist them in that fundamental exercise that they have to do. So against that background then, Chair, can I do the exercise which you will have to do in due course, you and the members of the tribunal? May I make some very brief submissions regarding the prohibited practice, and then I'm going to make some more. Chair, let me start with this. in my experience, the more provisions an applicant refers to in the Competition Act in trying to show that there's been a contravention of the Act, normally the weaker the case is. In other words, a very rough rule of thumb is the more provisions the applicant is going to refer to show a contravention, the weaker the case is likely to be. And with respect, that is the case here, because e-media and the founding affidavit refer to 5 provisions of the Act. One of them was abandoned today, at least for the moment, in oral argument. That's the Section 4 complaint. Another one didn't, in fact, another 2 didn't get any mentions in the course of oral argument. That's the Section 5 complaint and one of the abuse of dominance complaints. And so the lengths to which e-media went in their founding affidavit to create a prohibited practice is a pretty reliable indicator that they're on shaky ground. Let me nevertheless deal with each of the provisions on which they continue to rely, and let me deal with it quickly. Let me start with abuse of dominance. Chair, my learned friend Mr. Trenkov said I would deal with whether dominance has been established. I just don't have time to do that. We have dealt with dominance at considerable length in our heads of argument, and we continue to stand by those submissions. May I simply make one very brief submission regarding whether my client has been shown to have a dominant position in a relevant market? And it's this. The e-media case now is that the market in which the abuse is alleged to have occurred, and therefore in which Multichoice must be shown to be dominant, is the market for the acquisition and the onward supply of the rights to broadcast premium sports events. Premium sports events. And the one thing e-media don't tell you, and indeed the SABC don't tell you, is what makes a sporting event premium as opposed to, I suppose, the alternative would be non-premium. And they simply don't tell you that. Chair, let me give a simple example. I have never watched darts in my life, and I'm reasonably confident that I will never watch darts in my life, whether in a live show or whether on television. But because of a teenage prodigy in the United Kingdom, darts has apparently become an enormously popular television event in the UK. What does that mean for us? Is darts now a premium sports event when it comes to market definition, or is it not? We simply don't know, because that's something that e-media has never told you in the founding affidavit. And without that, it's very difficult to make out a case that Multichoice is dominant when we simply don't even know what the market is. Chair, can I say apropos that my learned friend Mr. Marriott today made, with respect to him, a most extraordinary submission. He said, when it comes to market definition, you take the applicant's version because it's interim relief. Well, with respect, that isn't correct. The test for resolving factual disputes is well established in the High Court and in the jurisprudence of this tribunal. But it's nowhere near as simplistic as saying you simply take the applicant's view. If that were the case, it would be very, very easy to make out a case for dominance. You would simply assert in your founding affidavit that the respondent is dominant, and the tribunal would have to accept that for interim relief. That, of course, is not the test. So if the founding affidavit doesn't make out an understandable, intelligible case for what the market is, then the case for dominance is also not made out. But let me move on for dominance, and let me make some very brief submissions regarding the 3 provisions in Section 8 which are relied on, assuming that they persuade you that my client is dominant in a relevant market at all. Regarding Section 8(1)(d)(1), which is requiring or inducing a supplier or customer not to deal with a competitor, my learned friend Mr. Trenkov has addressed that. There's nothing more I can add to that, Chair, and I don't intend to say anything more about that. Regarding Section 8(1)(d)(3), selling goods or services on condition that the buyer purchases separate goods or services unrelated to the object of a contract, or forcing a buyer to accept a condition unrelated to the object of a contract. The only additional point I wish to make to what my learned friend Mr. Trengove has said is it's to do with the question, Chair, you asked my learned friend Mr. Marriott when he was addressing the topic this morning. Your question to him was, what did he say about our complaint in our heads of argument that the SAPI two-market analysis is simply not performed in the founding affidavit? And Mr. Marriott's reply was, well, it is there because the two markets would be the upstream market, which is where the sports rights are acquired, and the downstream market, which would be the retail market. But Chair, with the greatest of respect to him, that is not the case pleaded in the founding affidavit. I don't have the time to take you to it, but I would simply ask you in your own time to go to the founding affidavit, paragraphs 170 to 174 at page 62. And this is what you will read. I'm not going to quote it. You will read that there's no objective justification for the impugned restriction. You will read that there's no rational relationship to the granting of a sub-license to the SAB. And you will read that it's unrelated to the object of a sub-license agreement between Multichoice and the SABC. But the one thing you won't read is any attempt to do the linking exercise in SAPI. It's just not there. Chair, the other thing SAPI said is regarding those words which form the fulcrum of E-Media's case, the way in which the tribunal interpreted those words in SAPI was to say that the condition (1D3) selling goods or services by forcing a buyer to accept a condition unrelated to the object of a contract. The way in which SAPI interpreted that is that's a case where a dominant firm sells to the buyer, doesn't insist on any other contract at the same time, but imposes a condition which, in the words of SAPI, would lead the customer directly to the door of the intended beneficiary in the second market. In other words, the condition leads the customer buying from the dominant firm to the intended beneficiary in the second market. Second market here, Mr. Marriott says, is the downstream market. But even on E-Media's reasoning, the SABC is not being led to the door of anybody in the second downstream market, not being led to any door at all. So even in terms of SAPI, putting aside that the point wasn't pleaded, even in terms of the reasoning in SAPI, the test is simply not satisfied here. Chair, regarding section 8.1c, I do want to make a few additional remarks to what Belinda and Mr. Trengove said. And the first is simply this. The definition of exclusionary act, Chair, as you and the members of your tribunal will know well, was amended so as to include the words participating in. So it used to say an act that impedes or prevents a firm from entering into or expanding within a market. When the amendment was done, the following words were introduced, or participating in. Now, why that's so important is that is the pleaded case. E-Media in its founding affidavit doesn't say that the alleged exclusionary act prevents it from entering into or expanding within the market. Its pleaded case is it is prevented from participating in the market. And why that is important is the meaning of that phrase, participating in, was considered by the tribunal in the order text decision, Polo and order text. And what the tribunal held in that case, in paragraph 53, is that participating in refers to the ability or the opportunities to sustain itself in the market. So the phrase participating in refers to the ability or the opportunity to sustain itself in the market. So what does that mean in the present case? Well, to come home under 8.1c, even at a prima facie stage, what E-Media must show is that the exclusionary act has an impact on its ability to sustain itself in the market. Now, why that's important, Chair, is if you listen closely to my learned friend Mr. Marriott this morning, when he argued this, his argument was what the impugned restriction did was to prevent additional growth by e-media in the market. And you'll remember he had to deal with that because the facts are so bad for him. The facts show that his client has had exponential growth in the downstream market, in the retail market. And so when asked, but how do you square that exponential growth with your reliance on 81C, the answer was, well, the growth would have been even greater if the restriction weren't there, although Mr. Marriott said he couldn't quantify what the additional growth would be. Well, the short answer is, Chair, it's entirely irrelevant, because when e-media tries to show that the Exclusionary Act has an impact on their ability to sustain itself in the market, it's irrelevant that their growth might have been better. What they have to show is that the restriction of which they complain has affected their ability to participate in the market at all. And Chair, that of course is what they haven't shown. Not just that they haven't shown that, but the evidence is entirely against them in that regard. Chair, my little Mr. Trengove gave you the numbers, but I'm going to ask you to go to the numbers in the affidavit, because I wouldn't want the tribunal to overlook those numbers. And there was a suggestion that the numbers may be confidential, but they aren't. I'm going to ask you please to go to my client's answering affidavit in the non-confidential bundle at page 370. Answering affidavit at page 370. And this is what my client says. The growth of OpenView can be assessed from two perspectives, namely the reported number of set-top boxes activations and its reported advertising revenues. In respect of set-top box activations, eMedia's own report reveals that OpenView has been able to grow its STB activations from 1.57 million in financial year 2019 to 3.17 million in financial year 2023. This represents a compound annual growth rate of 19% over this period. And then in the next paragraph, 133.2, you'll see that OpenView has almost quadrupled its advertising revenue between 2019 and 2023, and the numbers are set out. Chair, that is, with respect, a most extraordinary growth in the downstream market. And it's a growth that has been achieved by eMedia in the face of the restriction of which they complain. Because the OpenView restriction was enforced throughout that entire period. It is a strange case where a party comes before you, says that that is the way in which it has grown in the retail market, in the downstream market, in the face of the OpenView restriction, but nevertheless says that the OpenView restriction is an exclusionary act because it has had an impact on the ability of eMedia to participate in that market. The numbers say the exact opposite. And just to complete that part of the story, can I also ask you to go to a part of the record that Professor Vilakazi referred to this morning in a question to, I believe it was Mr. Marriott. It's also not confidential. It's at page 496 of the non-confidential bundle. Page 496 of the non-confidential bundle. And just to orientate you, it starts on page, it's obscured in my version, starts on page 494. This was an affidavit deposed to by eMedia in the High Court litigation. So it's eMedia speaking, it's not my client speaking. And if you go to paragraph 21 on page 496, this is what you'll see eMedia says. It's not even anticipated that the grant of the relief that's in the High Court case was an interdict to stop enforcement of the restriction. It's not anticipated that the grant of the relief would result in significant additional purchases of OpenView decoders. eMedia's sales of decoders did not increase year on end when it broadcast the 2022 Soccer World Cup in Qatar on SABC. History reveals that eMedia's sales of boxes are not linked to any particular event, and eMedia has no reason to believe otherwise in relation to the 2023 Rugby World Cup. That's from the mouth of eMedia. The removal of the restriction, allowing SABC to carry these events on OpenView, in their own words, would have no impact on the number of set-top box activations. And all of that is relevant to their complaint that this is nevertheless an exclusionary act. And Chair, where all of that goes is, our respectful submission is the case regarding abuse of dominance doesn't get out of the starting blocks. If you and the members of your tribunal were to take a different view of the matter, what would then become relevant is what is the competition harm? Because that must also be shown for eMedia to make out a prima facie case of abuse of dominance. So what are the anti-competitive effects? And you've heard a great deal about that today. Let me just make two very brief submissions in response to what we heard from our learned friends for eMedia this morning. The first is this: our learned friends say correctly that the jurisprudence of this tribunal says that there are two ways in which they can make out those anti-competitive effects. The one way would be to show actual harm to consumer welfare. The other way would be to show substantial or significant foreclosure of the market to eMedia's rivals. I'm sorry, to eMedia. Those are the two ways. Now we understood the main argument today of eMedia was in fact the first of those. So they suggested the shortcut was actual harm to consumer welfare. What is the harm to consumer welfare attendant on the OpenView restriction? They say, well, it's a very simple case. Viewers who are watching the SAB channels on OpenView are not able to watch these sporting events, the final of the Rugby World Cup, for example. Now, Chair, I'm going to repeat the submission I made earlier. That is the wrong counterfactual. It's wrong to ask, absent the impugned restriction. Let me rephrase that. It's wrong for eMedia to argue, if you cross out the impugned restriction, those viewers would be able to watch the Rugby World Cup on OpenView. The correct question to ask is, if you cross out the OpenView restriction, would the match be carried on SAB channels at all? Because would Multichoice still be prepared to sub-license to the SABC? And would SAB be prepared to pay the increased amount for the sub-license rights? That is the correct question to ask. So the shortcut on which eMedia rely is simply not available to them. The shortcut says, imagine the viewers now watching the Rugby World Cup. With respect, that shortcut is not the right one. It simply gets the counterfactual wrong. So if the shortcut is not available, all that's left for eMedia is the longer road, which is substantial or significant foreclosure of the market to rivals. And here the problem for eMedia is the one I've already addressed you on. They have to show that the OpenView restriction forecloses them in that market, but the evidence is all against them, Chair. I've taken you to the numbers. I've taken you to what they themselves said in the High Court. So with the greatest of respect, the foreclosure case for anti-competitive harm is also not one that is sustainable.
Mr. Cockrell, if I could just ask you on that, and maybe it's more to your first point there.
Yeah.
And you can tell me if I've misunderstood it, but the second part of the argument that your client advanced was that, well, one, we wouldn't have licensed to the sub-licensed to the SABC on the same terms, perhaps.
Yeah.
And you were describing this in your counterfactual. And I think somewhere in the papers and in argument, you've also said as a commercial decision, MultiChoice may, over time, or perhaps in certain instances, choose not to get these rights at all. And I think Mr. Trengo said this, right? On that second part, on the latter, I mean, how serious is that? I mean, if one thinks about the fact that, as I understand it, there's also great value to MultiChoice in the differentiation and having these products, and therefore being able to charge people subscriptions to access, you know, the best leagues in the world, the best tournament, or whatever it might be, right? So there's some intrinsic value to MultiChoice itself from acquiring the rights. From time to time, the seller of the rights requires MultiChoice to then also buy the FTA rights, right? And have to sub-license them, right? So that I'm struggling with that second bit, or at least that part of the argument that was advanced, which is that, well, we may choose not to buy them in the first place. That's kind of the first part of it. The second part of it is, well, if it's entirely MultiChoice's election to decide then at what price it gets to sub-license, and as such compensate itself for a premium paid or whatever it might be for the exclusivity from the original rights holder, then does that not in any event favor MultiChoice's commercial interests? Right? The SABC pays for the rights. In theory, you know, in theory at least, eMedia could be paying for the rights from MultiChoice as well. And in other markets as well, at least in terms of some of this theory, is that there are instances where the upstream provider of the input or the supplier has every incentive to have as many buyers as possible compete downstream and also pay premiums to buy the product. The more people that buy, the more I offset the cost of getting the rights in the first place. So maybe just to double back to the original question is what to do about that first part of the argument that was advanced.
No, I appreciate the question, Professor Vilakazi. Your question to me is how serious is, it's not really a threat by MultiChoice, how serious is MultiChoice when they say they may not acquire the rights at all? Professor Vilakazi, I don't know how serious they are. All that they say in the affidavit is that is a notional possibility. It's not intended to be a threat. It simply says that is a notional outcome in this counterfactual world, in this brave new world in which we live, where there is no open view restriction. So I can't tell you how serious it is. What I can say is the affidavit says that that is at least a notional possibility, and that must be correct just in terms of simple economic principles. On the second part of your question, which is what are the terms in which MultiChoice chooses to sub-license to the SABC, as my little Mr. Trengov said, those are ultimately matters of commercial negotiation between the parties. And obviously that's feeds into the earlier point. If the fee for the SABC becomes much greater, the SABC may not be good for the money. Professor Vilakazi, can I use your question, perhaps slightly abuse your question to deal with a related matter, which was dealt with by my little Mr. Marriott, I believe, in the context of this debate. It's this, and it feeds into your question, Professor, which is what are the obligations on MultiChoice when it comes to sub-licensing? Now, as you've already put to me entirely correctly, sometimes I'm just going to call it the head license, contains an obligation on my client MultiChoice to sub-license the free-to-air rights, and that would then be a subject of commercial negotiation. Even if that isn't there, Section 60 of the Electronic Communications Act also talks to this issue, but only in the case of certain listed events. So it's not the whole universe of sporting events, it's the listed events. But I need to just remind you what Section 60 says. Section 60 says, subscription broadcasting services, MultiChoice in this case, may not acquire exclusive rights that prevent or hinder the free-to-air broadcasting of national sporting events as identified in the public interest from time to time. I can leave out the rest. That must be read with the regulations made in terms of that provision. And what the regulations envisage in effect is that there will be, the regulations call it a tender, but we would say it's just an offer. When MultiChoice acquires the exclusive rights to those events, it makes an offer to free-to-air broadcasters to acquire those rights. But there is nothing in the Act, and this is the relevance to your question, Professor, there's nothing to suggest that that requires MultiChoice to accept a non-commercial offer from a free-to-air broadcaster for those rights. Let me take a simple example, Professor Vilakazi. If the Rugby World Cup rights are offered on a free-to-air basis in terms of the regulations to the SABC, and the SABC wants them for 100 Rand, there's nothing in the statutory regime that would require MultiChoice to accept that offer. It still remains a matter of commercial terms at the end of the day.
Sure. Maybe just to close the loop there, but is it fair to, you can correct me if my understanding is incorrect, because MultiChoice would then negotiate fair commercial terms as part of the sub-license, say with SABC. There's no favors being done, right? I presume that at the very least, whatever terms are then paid by or rates are paid for the license by SABC, etc., would at least cover MultiChoice's kind of incremental costs related to providing the FTA portion of the license and exclusivity to SABC, right?
At a minimum,
because I think Mr. Twengov also made reference to an economy class price, right? But even that still covers the cost in some reasonable margin. So there's money being made there in terms of at least a normal economic profit by MultiChoice, even in the sub-license. Is that a fair understanding of how this works?
Mr. Professor Vilakazi, I may get it wrong. One of my learned friends, one of my learned juniors can help me if I do. But my recollection of the MultiChoice affidavit is it says the fee that was negotiated with the SABC, certainly in the case of the Rugby World Cup, was below market rates. That's my recollection, but I may well be wrong, and hopefully someone will correct me if I am.
Sure, I think that would be useful to clarify, just so we kind of understand how, or the mechanism in terms of how this actually works. Thanks, Chair.
I'll make a note to come back to that if I may. Professor Vilakazi, I'm not sitting with my juniors. I'm in Cape Town and they're in Johannesburg, but I'm sure they'll be able to assist me, and I do undertake to come back to you in that regard if I may. Chair, may I then move on to the bits that haven't been covered on prima facie right? The one section we didn't hear, as I understood it, a word from in the case of eMedia is section 5.1. Now that is their pleaded case. They do rely on section 5.1. They haven't abandoned it, unlike section 4, which has been abandoned, at least temporarily. But you didn't hear a word from them on section 5.1. So let me just make some very brief submissions. The detail is in our heads of argument. You'll know that section 5.1 only prohibits an agreement between parties in a vertical relationship if it has the effect of substantially lessening or preventing competition in a market, and even then it's subject to being outweighed by pro-competitive gains. Now, the pleaded case made out by eMedia there is, where is the harm being suffered by the vertical restrictive praxis? They refer to the market in which the SABC competes with MultiChoice for viewers and advertising revenue, and they refer to the market in which OpenView competes with MultiChoice as an alternative platform provider. Well, the second of those is a non-starter for all the reasons I've addressed you on. It's just a non-starter to say that it has any negative impact on the ability of eMedia to participate effectively in the downstream market. The numbers show the exact opposite. And in the case of the SABC, again, there is no evidence before you to show that the SABC is being negatively affected in any meaningful way in its ability to compete with MultiChoice. You have a number of bold, bland statements by the SABC, but although they've gone on affidavit, the one thing they haven't put up is any empirical evidence to show what that impact is. So in our submission, there is no proof of substantial lessening of competition in a market for purposes of the Section 5 complaint, and it is also a non-starter. We know that the Section 4.1b complaint is a non-starter, at least for interim relief. And so where all of that goes is, in our submission, the case for prima facie proof of a prohibited practice is simply not made out. And if that is the case, Chair, the jurisprudence of this tribunal and the jurisprudence of the Competition Appeal Court says that's the end of the matter. You don't get into that balancing exercise of irreparable harm, balance of convenience, if no case is made out for a contravention of the Act. And in our submission, that is indeed the case. Chair, I intend no disrespect to Emedia when I say the competition case really is an attempt to force a square peg into a round hole. It's obvious what their complaint is. It's obvious what the intuitive force is of Emedia's complaint. The difficulty they have is trying to stuff that complaint or force that complaint into the wording of the Act, and that exercise is simply not done in our respectful submission. But Chair, what if you're against us on that? I need to make some submissions about serious and irreparable harm, because this hasn't been addressed by anybody today. Wasn't addressed by Emedia, wasn't addressed by SABC. And in this case, I'm not repeating what Belinda and Mr. Trengove said, because this was not part of the case that he intended to address. Let me start here, Chair. It's such a fundamental point. When one goes to section 49C, the second requirement that you must have regard to is the need to prevent serious or irreparable harm to the applicant. That's Emedia in this case. That is a requirement for interim relief. Our learned friends said in their heads of argument that there's no need to deal with that separately because harm also forms part of the contravention of the Act. And they're right, of course. When one looks at the contravention of any of the abuse of dominance provisions or the Section 5 complaint, harm is built in, it's baked in there. And so the logic of Emedia goes like this: because harm is baked into the contravention of the Act, there's nothing additional we have to do to show irreparable harm in the absence of interim relief. And with the greatest of respect, that is entirely wrong. And it's profoundly wrong in a way that has a big impact on Emedia's case. We made the submission in our heads that that was wrong. And we were expecting a response today in oral argument, but there was no response at all. So here's the difficulty for Emedia. When section 49C talks about irreparable harm, sorry, let me use the correct phrase, the need to prevent serious or irreparable damage to the applicant, it's talking about serious or irreparable damage to the applicant during the period of the interim relief. And you'll know that that is 6 months subject to further rollovers. So it's quite different to the High Court, where your interim interdict will last until the final determination of the matter. Here, there's an inbuilt time clause in the Act, 6 months subject to a rollover. And why that has an impact on Emedia's case is for them to establish that the serious or irreparable damage to the applicant requirement is satisfied. What they have to show you is not that there's irreparable, not that harm is made out as part of showing that the Act has been contravened. They have to show that absent an interim interdict in the next 6 months, they will suffer interim harm. Sorry, I'm getting myself mixed up. Absent interim relief in the next 6 months, they will suffer harm. And if that weren't the case, it would mean that every person who makes out a prima facie case is automatically entitled to interim relief, because the requirements would simply collapse into each other. And that's exactly what the Act doesn't say. So here's the problem for Emedia. Even if they persuade you that the prima facie case has been made out for a contravention of the Act, they now have to persuade you that they will suffer irreparable damage in the next 6 months in the absence of interim relief, and that is simply not addressed in their heads of argument. There's not a word on that topic. Not a word in the heads of argument, not a word in the oral argument. So that should be the end of the matter. But I'm going to address you anyway, briefly, on what they say in the founding affidavit, because the founding affidavit does make some brief submissions in this regard, but it doesn't help them on the critical requirement. Let me start with Let me start with harm to the SABC, because that is one of the legs on which e-media rely. They say, well, the SABC will suffer harm to its ability to fulfill its duties as the national broadcaster. But again, that is not going to help them at all when it comes to this requirement, because Section 49C says you must show the need to prevent serious or irreparable damage to the applicant. That is e-media, not the SABC. And even if that is wrong, even if you take a different view of the case, there's nothing on the papers to show that the SABC will suffer irreparable damage in the next 6 months. Nothing to make out that case whatsoever. And the same applies to e-media. In my experience, normally parties who come before you seeking interim relief, when it comes to making out this part of the case, normally they say something like, without interim relief, I'm likely to exit the market in the next 6 months. Now, they sometimes say that through gritted teeth. Sometimes they say that and it doesn't sound particularly coherent, but that is normally the case that is made out. If you don't come to my assistance now, I won't be here in 6 months, which means the complaint may well be academic. But that is what you will not find in the founding affidavit. That's the one thing e-media don't tell you. And it's to their credit that they don't tell you that, because they couldn't possibly tell you that, because we've seen the numbers. We've seen the numbers regarding the growth in set-top box activations, and we've seen the numbers in the growth of advertising revenue, and all of that has happened with the impugned restriction in place. So when it comes to this narrow issue, what is the irreparable damage that will be suffered by e-media in the next 6 months without interim relief? The answer is nothing. All they have is what my learned Mr. Marriott said today in a different context. Well, perhaps they would have sold more boxes, or perhaps they would have had more advertising revenue absent the restriction. But that, with respect, does not come close to making out the case for serious or irreparable damage to the applicant, which is what Section 49C required. Even if you're against us on the prima facie right, our respectful submission is that the case for irreparable damage is one that is not made out at all, and that would also be another reason why the application should be dismissed. And Chair, if you're against us on all of that, may I make some very brief submissions regarding balance of convenience? Again, a topic that my limited Mr. Trengove didn't address, so there's no risk of repetition in the submissions I'm going to make. I want to make 2 submissions in that regard, Chair. They are in our heads. The first is e-media says breezily that if an interim order were to be granted, there'd be no harm to Multichoice. Well, with respect, that can't be a serious contention. Just take the first leg of their relief. Assume that my client has an existing sub-license agreement with the SABC. The price included the open view restriction. Assume now during the next 6 months that event is broadcast and my client can't enforce the open view restriction. Well, that means my clients agreed a price with the SABC, what Mr. Trengove called the economy class price, and that price was agreed, and the SABC has now got a freebie without paying for it. That is a very real form of harm to my client, and it will never be reversed, even if the complaint were to be unsuccessful in due course. So the damage to my client is very real with respect. It's not non-existent at all. And that feeds into my second point regarding balance of convenience, which is in Business Connection, BCX, the CAC said, what should normally happen in this situation is that an applicant who asks for an interim order should tender to compensate the respondent if the applicant gets the interim order and fails ultimately in the complaint. And the logic behind it is, if you are lucky enough to get the interim order, but it turns out in due course that your complaint fails and you shouldn't have got the interim order, you must now compensate the respondent for the damage caused to the respondent by the interim order that you shouldn't have had. back to my example of the sporting event that was broadcast during the 6 months. My client wasn't compensated for that. It was stuck with the lower price it negotiated with the SABC. And that is relevant to balance of convenience. That's what BCX says. And although we raised it in our heads of argument, there is still no tender from eMedia to compensate my client in the event that it gets interim relief, but fails in the complaint. It's simply not there. And without that, it tilts the balance of convenience against eMedia. To put it bluntly, what eMedia tries to do is it wants the benefit of the interim order, but it doesn't want the pain if it fails in the complaint in due course. The pain is having to compensate my client. But with respect, the fact that it wants the benefit, but it won't incur the pain, is relevant to the assessment of balance of convenience, which also tilts against eMedia. So I've almost finished. May I, penultimate topic, make some brief submissions in response to what the SABC said today, my learned friend, Mr. Farlem. I'm just going to give you some references, if I may. I don't have the time to deal with it. 3 points in response to my learned friend, Mr. Farlem. The first is, my learned friend, Mr. Farlem, referred extensively in his oral argument to the SABC complaint. That's the complaint serving before the Competition Commission. But Chair, the complaint before the Competition Commission is not evidence. It's not an affidavit. It's just a shopping list of complaints. It's a list of grievances by the SABC. Those grievances may or may not in due course be shown out to be correct, but it's not evidence. And so, with the greatest of respect, the complaint does not provide any evidence of what the SABC complains about in its complaint. Second point, my learned friend Mr. Farlem referred to the provisional findings of ICASA in one of their reports. And my learned friend referred to that as being relevant to market definition. Chair, again, a provisional finding of ICASA, indeed even a final finding of ICASA, is not evidence before you. It's simply evidence of what ICASA found in the case of market definition. But that is not evidence before you. Second point, my client has never answered those provisional findings of ICASA on affidavit. It's never been called on to answer those provisional findings on affidavit. And Chair, third point, we have dealt with that issue in in Multichoice's conditional affidavit, the one that was admitted into evidence this morning, Chair, shortly after we began the hearing. We've dealt with those findings in paragraph 24 to 25. And lastly, on that topic, Chair, I would simply ask you and the members of the tribunal in due course to read what those provisional findings of ICASA were. Because with respect, not all of them were correctly represented by my learned friend today, Mr. Farlem. I don't for a minute suggest that he intended to mislead the tribunal. The only submission I do make is that what he did say regarding the findings of ICASA is not correct in all respects, but you will be able to read that in your own time. And then lastly, Chair, my learned friend Mr. Farlem addressed you on various complaints regarding Multichoice's acquisition of the free-to-air rights. Chair, my client has dealt with that in the conditional affidavit that was admitted this morning. I would simply ask you to have regard to paragraphs 49 to 59, which deal with that very topic. For all of those reasons, then, let me just conclude. What does my client ask for? My client asks that the application be dismissed. My client doesn't ask for costs, because on the jurisprudence of the CAC and indeed of this tribunal, the tribunal doesn't have the power to give costs in this sort of application for interim relief. And it cuts both ways. In their heads, eMedia continue to ask for costs if they are successful. But with respect, the tribunal doesn't have the power to give a cost order. That's what BCX held. Chair, I'm going to ask you, may I simply take a brief instruction regarding the matters that I said I would come back to Professor Vilakazi on, because I do owe him an answer in that respect, and I'm hoping that one of my learned juniors will be able to assist me with the record reference that I had in mind. May I simply go off camera, Chair? It won't take very long.
Yes, Mr. Parker, you can do that. Yeah.
Thank you.
Chair, would it be convenient for me to fill the empty airtime with responding to giving a reference in response to your earlier question, or shall I wait until Mr. Cockrell is finished?
Mr. Farlam, I'm sure that you can give that to us. It's just the reference.
Yes, so thank you. In our in the confidential bundle, it's pages 250 to 254 and pages 300 to 302. And then, so it's 250 to 254, 300 to 302. And to confirm that I did represent the position correctly, there were decisions of European competition regulators that said that there should be an unbundling of the rights. And just for example, at 301, it says partial unbundling, that rights must not be sold in one bundle to one media company, but must be unbundled in order to prevent foreclosure in the broadcasting market and potentially inevitable broadcasting monopoly. That's at 301, para 180.1. And then there are footnote references in our complaint to various European Commission decisions, which have generally been in relation to association football, soccer.
Thank you, Mr. Farlam.
Thank you very much.
Thank you, Chair. Chair, I've managed to, or I can't say I've managed to find, I've been directed to the passage that I had in mind, and I'm glad that my memory wasn't playing up. It's the answering affidavit of my client. It's paragraph 80 at page 358 of the non-confidential bundle. And this is what my client says. I emphasize that the amount paid by the SABC under the sub-license agreement was far below the market value for the rights and was far below the amounts paid by the SABC for the rights to the 2011 and 2015 Rugby World Cup. So, Professor Vidakazi, that's what I had in mind. You asked me, can you accept that the current sub-license fee would at least allow my client to cover its cost and make a margin? And the answer is, my client says that certainly in the case of the Rugby World Cup sub-license, the fee was below market value. Chair Sabridge, any questions you or the members of the panel may have, those are the submissions for the multi-choice respondents.
Yes, thank you, Mr. Cockrell. We can check if there are questions. Ms. Mzwa.
Yes, just one question, Mr. Cockrell. You referred us to paragraph 47 of the order text decision, which deals with how we are to deal with disputes of fact, and we're required to look at clear and non-controversial facts for purposes of interim relief. Now, there seem to be disputes of fact around the market definition. E-Media has suggested alternative market definitions. SABC has also proffered some. Multichoice has disputed those market definitions, but hasn't provided any alternative market definitions. Now, in the context of the CAC decision in E-Media and Multichoice, the earlier decision, which actually refers to this clear non-controversial facts, and which also calls on us to look at, take a robust approach in instances of disputes. How are we to deal with this issue? Are we at liberty to take a robust approach on market definition, and does that also apply to a robust approach on anti-competitive effects and the other factors, irreparable harm and balance of convenience?
Yes. Yes, I'm grateful for the question. Ms. Y, with respect, the answer will depend on whether it's market definition or something else. And let me explain why I make that submission. In the case of market definition, there's no need for this tribunal to form a final view on what the market is. That's what it held in Bulbman. I believe that's a case cited by our learned friend Mr. Farlam for the SABC. So certainly it's not part of our submission that you have to form a final view regarding what the market is. But what the applicant, eMedia, does have to satisfy you is that my client is dominant in a relevant market. If the market they've defined is simply not fortified by any facts, then with respect, they haven't made out the case. And it's not a question of forming a robust view. It's a question of saying that eMedia didn't make out the case for the market that they advocate for. And that is our submission. You'll recall, in fact, let me ask you to go, if I may, let me ask you to go to eMedia's founding affidavit, because when we criticize them on market definition in our answering affidavit, their response in reply was, you don't have to go any further than paragraph 97 and 98 of the founding affidavit. So let's take them at their word. Let's go to those two paragraphs, if we may. Paragraph 97 and 98 of the founding affidavit, you'll find that at page 38. Bear with me. So eMedia says this is good enough for their market definition. And this is in response to your question, Ms. White. Can we take a robust view given that this is the case? Well, this is what they say. Paragraph 97. Multichoice already has market power in the television broadcasting sector as a whole. I can stop there. The rest of the sentence doesn't matter. Well, not even eMedia says that the television broadcasting sector is a market. And it can't be. Whatever it means, I don't know what it means, but whatever it means, they don't suggest that it's a market in antitrust terms. Can I then go on to the next sentence in the same paragraph? Multichoice's financial muscle is particularly relevant in the context of the acquisition, licensing, and broadcast of premium sporting events. As a first mover, it has secured the overwhelming majority of upper LSM viewers, and therefore, it has an entrenched position in relation to the acquisition of television rights to premium sporting fixtures. If one just looks at the last sentence, it doesn't make any sense. The fact that, assuming it's correct, the fact that Multichoice has secured the overwhelming majority of upper LSM viewers in the downstream market, in the retail market, doesn't justify the conclusion that therefore it has an entrenched position in relation to the upstream market, which is the one for the acquisition of television rights to premium sporting fixtures. But even if that's the case, you'll ask yourself, what is a premium sporting fixture? And eMedia simply doesn't tell you. And the problem just continues in the next paragraph, 98. This matter relates to the acquisition and onward supply of the rights to broadcast premium sports events. Multichoice is a dominant firm related to the acquisition and supply of premium sport content in South Africa, with the market share in eMedia's estimation of more than 90%. Now, Ms. Mazwai, that is the case. When you ask yourself, as you should, what is the 90%? What is the numerator? What is the denominator? You simply aren't told. It is literally just a thumbsuck. Is the denominator the number of events? Is it the I don't know, is it the amount paid for the events? What is the denominator and what is the numerator? We simply don't know. And so, Ms. Mazwai, with respect, the answer to your question is, it's correct you can take a robust view on market definition and don't have to come to a final view. But the applicant must at least make out a case to show you why it says that my client is dominant in a relevant market, and that is the case. It just is a non-case with respect. There's nothing there to support the 90%. When it comes to the other elements you refer to, irreparable harm and balance of convenience, in our respectful submission, that's different to market definition. In that case, it is a matter, the relevant question is not can we adopt a robust approach? The relevant question is any case been made out to show that eMedia will suffer irreparable harm in the next 6 months in the absence of interim relief? And the answer to that is no. The tribunal can be as robust as it wants with the facts, but no amount of robustness is going to give a positive answer to that question, because there's nothing to show that eMedia will suffer irreparable harm in the next 6 months.
And so just a follow-up on that and related to market definition, is there any evidence from Multichoice's perspective about any other broadcaster that acquires the right to supply premium sports events?
Only the SABC, that's the only evidence you have. The SABC is competing in that same market, of course. No, there's no evidence regarding any other party, no.
Right,
So,
thank
Mr.
you.
Cockrell, if that is so, why should we not assume that your client is dominant in that market? So I think that what the applicant is saying, whatever the numerator is, your client is dominant in that market. So we don't have to determine the denominator.
Yes, but you must at least know what the market is. You must at least know what a premium sporting event is with respect, Chair. And that's what they don't tell you. I'll go back to my silly example of darts. Is darts now a premium sporting event? They must at least offer some way of distinguishing between premium and non-premium. That's their burden, and they haven't made any attempt to address that burden.
Check if there are further questions. Professor Vilakazi?
None, Chair. Thank you.
Thanks. Just one question from my side, Mr. Cockrell, and that is how we should deal with the arguments regarding counterfactual. So your client puts up notional counterfactuals. Of course, because we're in the interim relief world, we don't hear evidence to decide which counterfactual is real and which not. So, I mean, how do we, in an interim relief setting, deal with arguments about a notional counterfactual? Again, my colleague said, well, should we take a robust approach? Should we take a robust approach then in relation to what the counterfactual is, and what does that mean for where we land?
Yeah, no, yeah, thank you. I'm grateful for the question. Jay, you're entirely correct. No one knows what that counterfactual world will look like. So if you were to cross out the so-called open view restriction, it's impossible to predict what would happen in that counterfactual world. But what my client tells you on affidavit is the one thing you cannot just assume, which is what eMedia asked you to assume, is assume that life will continue as normal and that OpenView viewers will now have access to those events on OpenView. That's the one thing you can't do, because it's simply a matter of basic economics that if my client were forced to negotiate a fee with the SABC, the fee would be greater. That's what it tells you. If you ask me, do I know whether the SABC would be good for that fee, or do I know whether Multichoice would still want to acquire the rights? I can't give an answer to that. We simply don't know. The one thing we do know is that the SABC would have to pay more, would have to pay considerably more, and they've told you that they are cash-strapped.
Thank you. Mr. Marriott, are you doing the reply, or is it Mr. Du Plessis, or both of you?
It's both of us, but I will start, Chair.
Thank you.
Chair, I don't want to repeat what I've already said, and I intend to be as brief and succinct as possible. My learned friend, Mr. Trengrove, started with an outline of 5 facts. I have dealt with most of those in my opening address. I dealt with the question of exclusivity. I dealt with the need to differentiate. I explained and submitted that there's very little in the way of robust evidence, or any evidence indeed, to support the notion that there is any value to the differentiation and exclusivity which remained. And I made the point that, in fact, it's pretty clear that this is a provision which was inserted into the sublicense in order to inflict harm on eMedia. The 5th point that he made overlaps with the submissions made by Mr. Cockrell, which he said, you careful what you do, tribunal, because if this application is permitted, well, there may not be any sport at all. Mr. Cockrell broadcast on DSTV, and Mr. Cockrell called that the counterfactual. That has been debated with him. I just wish to add this important consideration. At the time that Multichoice concluded these agreements with the the sports bodies in question. It knew about the provisions of Section 60, that it would have to sublicense events of national importance. It knew, in most cases where it obtained free-to-air rights, that the sports rights holder itself would insist that there would be a sublicense granted to a free-to-air broadcaster. Notwithstanding that knowledge and the knowledge that the exclusivity and the ability to differentiate would be pared down significantly as a result of the grant of that license to a free-to-air broadcaster, they paid what they did. It doesn't lie in the mouth of Multichoice. And I should add, they had no idea at the time that they concluded that agreement that they would get assent from the SABC for those rights. They had to do it. They had to, and they were obliged to sublicense, and they could have no guarantee as to what amount of money they would get from the SABC, but they did it anyway. And that puts paid to the submission that there is a realistic, commercially reasonable, rational world in which Multichoice will not acquire these rights. It will always acquire these rights. So the counterfactual and the scaremongering which is associated with it, frankly, doesn't get out of the starting blocks. That's a critically important point, because when my learned friend Mr. Cockrell addressed you, and I believe it was only him that addressed you on the question of consumer harm, his sole submission related to this counterfactual. He said to you, well, eMedia's case is simple. The person who's invested in the OVHD decoder now is inconvenienced and frustrated by the fact that they can't watch the DSTV, seemingly accepting that that is indeed consumer harm, as he must. But he said, but you've got to compare it to the counterfactual, and the counterfactual is that there wouldn't be any sport at all. But if he loses on the counterfactual, then where is Multichoice on the question of consumer harm? The answer is nowhere. There is clearly consumer harm established on the facts of this case, and Multichoice has no answer to it. And on the SAA jurisprudence, that is enough. That is all that we need to get to come home on the prima facie case. Professor Vilakazi raised one point in the one issue with respect to consumer harm. He said, well, you know, consumers may have other options. Consumers, when I say consumers, OVHD viewers, OpenView viewers may have other options. But what are those options? They are expensive in the form of trying to stream content on SABC Plus, for which you need a proper internet facility, which most people in this country cannot afford. Or you have to sign up to DSTV or to Starsat. And this in circumstances where you as the OVHD have already invested in an OpenView decoder. Those aren't options in truth. Those are expensive, inconvenient, harmful options that would that consumers would have to consumers have to suffer just to see content which would ordinarily be available on SABC2.
So, Mr. Marriott,
yes,
just on that, is that to say then that those consumers are not expected to default to, I suppose, old school kind of analog viewing, especially in the provinces where it hasn't been shut down? Am I understanding you?
There's only 4 where it hasn't been shut down, so there's a lot that can't default. There's over the course of the next 6 months, there will be many more provinces shut down. In fact, in certain provinces where it is still up, it has been shut down even within segments of the. So yes, I'm saying that the ability to default to analog is limited already, but will become increasingly more limited over the next 6 to 12 months. So I've dealt with the 5 points in consumer harm. Just another introductory point. Mr. Cockrell, when he started his address, said that I had said that the constitutional points addressed by Mr. du Plessis were relevant directly to irreparable harm. I didn't say that. I said that they were most relevant to the question of anti-competitive effects. And that is so is clear from the Apollo Studios judgment, paragraph 53 and 54. 54 I'll just read. It says, in addition, for the reasons explained in MediClinic and eMedia, the competition authorities must be particularly alive and sensitive to the anti-competitive effects that may be felt in South African markets as a result of exclusionary conduct by dominant firms, especially insofar as it is directed at historically disadvantaged persons and small and medium-sized enterprises, which is exactly what I had said, in the opening part of my submission. I didn't say it was relevant only to irreparable harm. In fact, my submission was that it is principally relevant to the question of anti-competitive effects. And I said in that context that consumer harm, that it's easy to apply to consumer harm because constitutional consumer harm is really, in all respects, it equates in all respects with harm to consumer welfare. Then, on the questions of the provisions of the Act relied upon by eMedia, both Mr. Cockrell and Mr. Trengrove dealt with these provisions. Mr. Cockrell started his submission with a perhaps tongue-in-cheek submission that any party that relies on a lot of provisions generally indicates to you that they have a weak case. It's funny, I had thought that a party that relies on a lot of provisions is one where the conduct is so egregious that it contravenes many sections of the Act, but I guess it's a question of different experience. But what was striking in both the submissions of Mr. Cockrell and Mr. Trengrove is the extent to which they skipped over and dealt with in the briefest possible terms Section 81D1. What did you actually hear about Section 81D1? Mr. Cockrell said that Mr. Trengrove had said everything that needed to be said about it. But what Mr. Trengrove had said was very limited indeed. All he said was that, and let's just get my notes. Firstly, that the bundling, that the grant of a license to part of the bundle of intellectual property is common, and I dealt with that in my opening address, and with reference to the three cases, said yes, that is so, but that the mere fact that you've only granted a license to part of the bundle of rights doesn't mean that there can't be exclusionary abuses which arise through restrictions imposed on the licensee in that agreement. And there was no answer to that submission. And the only other point made by Mr. Trengrove under Section 81D1 was that, well, you're still dealing with eMedia. SABC is still dealing with eMedia because the SABC channels are still on eMedia. That is really no answer to eMedia's case under 81D1. It is not dealing to the extent that it otherwise would. SABC is not dealing to the extent that it otherwise would with eMedia. And if you're going to find that, oh, well, you can cut off dealing to some extent, provided there's dealing in other contexts or in other markets, and then, you know, in those circumstances, 81D1 is not applicable, well, that would render the section nugatory. It is clearly intended to cover if you prevent or no, I don't have the words in front of me, but it's not an absolute requirement that you must cut off all dealing. So that's all you heard about Section 81D1. And we don't need to come home under every section. One section is good enough. And with respect, the case under 81D1 has only strengthened over the course of the afternoon. My learned friends did spend some time on 81D3 and Section 5 to make the point that I hadn't spent a lot of time. I didn't spend a lot of time. I didn't need to. It's in our heads of argument. I didn't abandon them. It's dealt with in the heads, but given the strength of the 81D1 case, I didn't frankly think it was necessary to do so. I don't therefore intend to deal with it in reply. As I say, the provisions are our submissions are in our heads. It's also just to note, it was suggested that I had argued an 81D3 case on leveraging, which doesn't appear from the founding affidavit. In fact, what I said is mirrored on page 60, paragraph 162 of the founding affidavit, in which we explain that MultiChoice is using its power in the market for the acquisition and onward supply of sporting content to extract an advantage against e-media in the downstream market. So those allegations are indeed made. Just on section 81C, my learned friend Mr. Trengrove accepted that this conduct gives rise to harm to e-media's goodwill. He sought to make a virtue of it, saying that that's just competition on the merits. But it's not at all. He made a further concession when asked by Professor Vilakazi, well, does the sporting body obliges you to grant a sublicenses, but leaves it to you, MultiChoice, to decide what the terms of that sublicense are. And he accepted that that was so. And therein, that is exactly what I was saying in my opening address. MultiChoice has used the opportunity of the sublicense to extract or to impose a restriction which is intended to humiliate, to harm, and to undermine the goodwill of e-media. That's what this case is about, and we say that that is not competition on the merits. It's intended to hobble the only viable competitor in the basic satellite market. So the other primary submission made by, in particular, Mr. Cockrell, was that, and as anticipated in the Hezavong, is that e-media is growing, and he expressed some amazement, I guess is the word, that e-media would seek to even bring a case based on under Section 81C in circumstances where it is growing. If his suggestion is that anti-competitive abuses cannot be carried out against firms that are growing, then with respect, that is plainly wrong. In fact, is it not the position that firms that are growing are the most likely targets of abuses of dominance? Why would you need to take action or abuse dominance to if the firm was going down the tubes anyway? So the position, as I said in my first round, is that the question is not whether we were growing or not. The question is, would we have grown more absent these restrictions? We say we would have. And the question is, that's the first point. And the second point is that it is precisely because e-media is growing and the delicate state of this market that this tribunal has to be very vigilant to take action to preserve the delicate competitive positions and the somewhat tenuous position of e-media in this market against the behemoth that is MultiChoice. Finally, on this question of growth, I note that, of course, in the last round, the channel was, of course, e-media was growing then too, and there was no bar. That was no bar to the grant of interim relief in that case. And in fact, at paragraph 102 of the e-media judgment of the CAC, first granting the interim relief, just need to find it. Sorry, the court, I've given you the reference. The court, in fact, referred to the fact that it was important to take action. Sorry, it's my attorney will give it to me. They said MultiChoice is in its well-entrenched dominant position loses sight of the fact that its position will remain entrenched. It does not have to preserve this position at the expense of a black-owned, medium-sized competitor like e-media that was just gaining traction in the basic satellite market. And that's exactly the point. Yes, there might be growth, but it's gaining traction, and it's precisely for that reason that you need to take action where necessary. Then there was a suggestion that the SABC paid an economy class ticket price. We dispute that, and we point out, just to give you a reference, that the number is at paragraph 41 of our heads of argument, page 23. It's confidential. I can't read it to you. But what I want to say about it is this. This is a number that was agreed to after the competition had already started, in circumstances where SABC was never going to be able to monetize its license properly because the thing had been concluded at the very last minute. And despite that, the SABC still paid what it paid and what one can see in paragraph 41 of our heads. And we say that that's not economy, that's business class. In fact, Multichoice derived a great deal of benefit from this license. And it is also for that reason somewhat it's hard to concede or conceive that Multichoice could in any world have asked for more, simply to remove the e-media restriction. And again, I go back on this question. You must remember that at the time that they concluded that agreement with the Rugby World Cup, Multichoice didn't have a guarantee of a cent. They knew they had to sub-license, but they didn't have any guarantee, and so of receiving anything. So everything that they receive is in fact a bonus, and they clearly extracted what they could. That's why they didn't tell the SABC that they had to sub-license. They extracted what they could, and there's no suggestion that they could have extracted more. That I want to give my learned friend, Mr. Du Plessis, some time. Those are my submissions, Chair. We say we've done more than enough. Oh, sorry. On the question of irreparable harm and balance of convenience. Irreparable harm, we have made out a case. One can go to page 80 to 82, where paragraph 238 in particular, where we spell out in chapter and verse the irreparable harm to e-media that will be suffered over the next 6 months, including in relation to the events, common cause, that are going to happen over the next 6 months, ICC T20, PSL games, MTN Cup, Nedbank, etc. We've made that case, and I addressed it this morning in detail. I explained that about the brand and the damage to the goodwill and the reputation and how it's impossible to quantify, and for that reason irreparable. My learned friend says I didn't address it. I didn't address it under a separate heading that said irreparable harm. What I said when I got to irreparable harm is I said I've addressed you already on the question of harm to e-media. That harm is to the competitive position of harm to e-media in the market, and everything I said appears from page 200 from paragraph 238. As to balance of convenience, again, that goes back, and this is what I said last time around. Multichoice hasn't quantified at all, and I said they would have if it was the true reason, at all what value they ascribe to this incremental exclusivity. And if they can't ascribe a value to, what it means to them not to have this on OpenView, then they can't seriously claim to be prejudiced by an order that they carry the content on OpenView. Thank you, Chair. I don't want to overstay my welcome. Those are submissions. On costs, we don't seek costs.
Yeah. Mr. Du Plessis, if we can request you to be brief, please.
I'm going to do my very best, Mr. Chair. The first point is Mr. Farlam's correction. Mr. Farlam corrected the fact that in paragraph 27 of our heads, we had quoted what was in fact from our reply rather than from what had been said by SABC in its answering affidavit. And he has very helpfully corrected that as a formal error, but of course he has confirmed, and again very helpfully, he's been very diplomatic to be fair to both sides. He has confirmed that that statement that you see there as reflected is in fact accurate. And that statement is, and I have to read it again because it really puts paid to so much of what we've heard this afternoon, is that in broadcasting the SABC's channels to around a quarter of the SABC's national audience, e-media assists the SABC to fulfill the public's rights of access to information and the expression and discharge of its mandate under the Broadcasting Act to make its services available throughout the Republic. That is what the SABC sees eMedia is assisting it to do in relation to broadcasting rights of access to information. So you have the national broadcaster telling you that access to information and broadcasting is important, and that we are assisting them as eMedia to fulfill that particular role. And that is why, with respect to Mr. Trengrove, was incorrect to say that SABC alone has the duty to provide the service, not eMedia. That is not the case. As SABC itself tells you, it cannot do the job as the national broadcaster to 20 to 25% of its viewership without eMedia's assistance. And it's also therefore incorrect for our learned friend Mr. Trengrove to say that the public is not entitled to receive sports broadcasting, as he put it, free of charge. Well, it's not free of charge, not at all. It's paid for by the public. Firstly, that 20 to 25% that SABC wants to reach, it's paid for by them through their payment for an OpenView decoder. They had to pay for the OpenView decoder. And that was something they had to pay for. Professor Vilakazi has noted this in the context of digital migration, as there's a shutting down of various channels, the audio channels, the original channels across the country. And that, therefore, is the only means by which you can then continue to watch this particular program on an OpenView platform. So they paid for that. Not only have they paid for it by getting the satellite opportunity through the OpenView platform, they've paid for their provider. They've also paid their TV licenses. So it's not free. It's not free in two ways. And with respect, it's not some uppity bunch of viewers, with socialist leanings that are insisting on continuing to see things for free. It's 20% to 25% of the SABC's viewership that the SABC wants to reach, but it cannot reach because of this particularly restrictive clause, which punishes not just eMedia, but also 20 to 25% in the millions of people who would otherwise wish to have seen so. And it's therefore a public good that they are being denied. And we stand by that statement. Repeatedly, we were told, including by, I think, our learned friend, Mr. Cockrell, that this is just about economics, and that we as eMedia have left out of, in our constitutional arguments, the economics of how one buys premium sports content. But with great respect, we haven't. What has been left out of the equation entirely by our learned friends is that the sub-licensing is purchased by the national broadcaster with public funds. They broadcast on the basis of taking your and my money and buying the particular content, and then ensuring that viewers who have an OpenView platform, who have bought that particular service through the OpenView box, are then entitled to watch that which they're entitled to as a public good. That is entirely left out of account, with great respect, by learned friends' arguments. Let me very briefly then also say that in this context, I think it was Professor Vilakazi, and I just want to give you the references, I don't have the time, it was making the point, well, that there had been viewers that had complained that they hadn't been able to watch rugby and so on. It's not just complaints, Professor Vilakazi, it's reputational harm as reflected. You'll see this in 3 media statements. They are at page 125 and page 126 and page 177, 125, 126, and 177. I'll just read you the flavor of 125. This is a media statement by the SABC, and I'm asking you to keep in mind the question of reputational harm to eMedia when this is something said by the national broadcaster at page 125. It speaks about the SABC confirming that they've concluded an agreement with Multichoice to broadcast all the Springbok games. Total of 16 games will be broadcasted on the SABC channels. And then you read the next sentence. This agreement will unfortunately exclude OVHD eMedia's platform because of the restrictive conditions that Multichoice is placing on the sub-licensing agreements for the Rugby World Cup. This condition cuts off approximately 3.2 million South African households. So the other media statements are to similar effect. So you have the reputational harm there said by anybody that reads this about the SABC's difficulties as being something which, if you're the owner of an eMedia box, you are immediately one of those 2.3 million people who don't have access to that television. And in that context, let me just finish, if I may, on this point, that we have the SABC's advocate in the form of our learned friend, Mr. Farlam, telling you that And he did it as diplomatically as he could. He wanted to be balanced and fair to everybody, but nevertheless, his words rang true and very powerfully as to the harm. He said, there's clearly anti-competitive effects in the market. He said, these effects are on viewership of the public. He said, this is harm to the SABC in terms of advertising that they cannot monetize. And he said, MultiChoice's pressure and the abuse of dominance was manifested in the negotiations with the SABC. They had to agree, he said, to the clause, even though it affected millions of their viewers. So you can have lots of interesting debates about exactly what the standard is and whether you need to adopt a robust standard, as Ms. Mazwai was debating with our learned friend Mr. Cockrell, and where the evidence lies. But you've got that from the national broadcaster, and you know, therefore, exactly what the difficulties are. Next point, very briefly, is that our learned friend Mr. Trengrove said that nobody has done more than Supersport to bring sports to the public. Nobody has done more than Supersport. Well, but of course, the fact that you've done a lot in the past and you've earned a lot of money in doing so, that doesn't give you the right or the license to cut off 20 to 25% of the public by abusing your dominance. That's what we hear about, not about how brilliantly Supersport may have done in the past. It's about what it is doing now in the short to medium term to prevent the continuing viewership of these types of premium sporting events. And it has been sub-licensed at significant cost pursuant to a particular statutory provision, Section 60 of the ECA, to the public broadcaster, which is then limited from being able to reach millions of its own audience, all of whom pay their own TV licenses. In that context, I think it was perfectly correct, with great respect for Ms. Mazwai, to point out that MultiChoice has also had the benefit of state aid previously. And our learned friend, Mr. Trengrove, said that he didn't understand e-media or me to have based our arguments around that. But with respect, I then need to be clear. I had made it palpably plain in reading out from Media 24, the judgment that I specifically said was critical, that it is about past privilege, and it is about being able to platform off that privilege. You'll remember I read to you from paragraph 31 of the judgment, and of the Media 24 judgment of the Constitutional Court, where there I said to you, and I said the critical part of that passage was as follows: consumer welfare lies at the heart of the matter before us. And I read the next sentence, stressing it. I said the prohibition of abuses of dominance is recognition of the fact that dominant firms attained this status due to our exclusionary history. I then also went on to read to you how in the Competition Appeal Court's decision in e-media, Justice Victor was critical of MultiChoice having its entrenched dominant position and using it to exclude a new entrant who was growing in the market in the form of e-media. So that is certainly part of our case. And in that context, I would just draw to your attention that I didn't mention this in my oral address, but it's clearly set out to complete this point in founding affidavit for e-media at page 36 of the non-confidential bundle, where at paragraphs 88 onwards, you see, we say just this. We say at 88, MultiChoice is the beneficiary of a state-conferred monopoly position that allowed it to achieve a dominant position in the satellite TV industry in South Africa. 89, it was the first paid TV station in South Africa, Mnet, and the first privately owned television platform from 1986. This license was granted prior to the advent of democracy in South Africa, etc., etc. So it has had that first mover advantage, and we do lay store to it. And in that context, then you need to be cognizant of precisely what is said by e-media CAC by the Competition Appeal Court, I should say, in the e-media case at paragraph 102. Mr. Marriott read it for you. He stressed the second part of that paragraph. I need to stress the first part, and I'll read it to you. It said, MultiChoice, in its well-entrenched dominant position, loses sight of the fact that its position will remain entrenched. So there's no risk to MultiChoice. It hasn't shown you, as my learned friend Mr. Marriott has said, that there's going to be any prejudice to it. Well, we already know why, because its position will remain entrenched. And so in that context, the really important part of that paragraph is the second sentence. It doesn't have to preserve this position, said the Competition Appeal Court, at the expense of a black-owned medium-sized competitor like e-media that was just gaining traction in the basic satellite market. Then, if I may, very briefly, and I've got two final points to stress in 2 minutes, and that's Mr. Cockrell's point. He made reference to the argument that if there was any rights that were an issue in this case. They were Multichoice's property rights. Now, with great respect to our learned friend, he repeatedly used the phrase that numbers of our points supposedly didn't get out of the starting blocks. Well, we disagree with him entirely. But this point doesn't even get onto the starting blocks. A property right that Multichoice is wanting to try and use to defend itself against an abuse of dominance. Well, firstly, we know there's the Constitutional Court judgment in Mediclinic, where the Chief Justice said that you cannot lay store or lay claim to the pure driven pursuit of profits in a manner which is going to be acceptable to the Constitutional Court or to this tribunal. So your property rights are never going to be an absolutist excuse, which is what effectively amounts to the position in this case. And secondly, in any event, and I don't want to bore you with the jurisprudence around property rights, but it can't possibly be a violation of Multichoice's property rights because the Constitution says that a law of general application may well limit rights. The law of general application that limits rights in this case is the Competition Act. And the Competition Act gives you power to ensure, where necessary, that you can protect against abuse of dominance. When you do that, that's not a violation of property rights. That's a perfectly justifiable limitation of rights in the interests of, as it turns out, the rights to freedom of expression of millions of people in the country. So the property rights defense really, with great respect, goes nowhere. If I can then just highlight in closing what we didn't hear anything about in any meaningful way. We didn't hear any meaningful dealing with the Mediclinic injunctions that I read to you from the Chief Justice, or that which was said by the Competition Appeal Court in e-media. It wasn't dealt with, therefore, in heads, and we didn't really hear anything about it in oral argument. And we didn't hear about the duty that is on you as the tribunal members with respect carefully to consider context. I repeatedly said that in my oral address. You have to consider the context. That's what the Competition Appeal Court in e-media stressed. In these cases, context-specific, constitutionally sensitive approach is what's required. And you also didn't hear anything about avoiding the abuse of dominance in the broadcasting environment to protect against consumer harm, in particular, where that consumer harm is going to be to the detriment not only, obviously, of e-media, but the consumer welfare of 20 to 25% of the population. You effectively had an argument that said, it amounted to this. Well, they're not entitled to it for free. That was the argument. They're not entitled to it for free. And in this context, it may be a consequence of what happens, but then there's the counterfactual that Mr. Crocker posited. But with great respect, I think, Mr. Wessels, with respect to you as the chair, you were absolutely right to highlight that at an interim stage as this, there's no evidence about that. There's no evidence about the counterfactual. And the tribunal knows that from Mr. Cockrell's own mouth, he said, well, we might have had to charge more, but he said he just doesn't know. He just doesn't know. Well, neither do you. What we do know is that there has been a payment made of money that is confidential. I won't mention it further, but by SABC to have these rights. They paid that money in circumstances where they wanted to. They repeatedly told Multichoice, we want to be able to sublicense in a manner which gets our, our viewership, 20 to 25%, millions of our viewers, able to see these events on the e-media platform. They were denied that right. They were told, no, we're not going to permit you to do so. You have to sign this clause. And in the context of having signed that clause, we're now sitting in a situation where who else but e-media, together with SABC now, effectively accepting that we are partnering or we assist them to ensure that viewership is provided, could come to bring this abuse of dominance to heel. And we've done so not only in the discharge, as we say, of e-media's rights, but also more broadly of a vindication of what we say are the constitutional rights at issue in this matter, and which you as the tribunal, with great respect, are required to consider in the exercise of your discretion. Unless there's anything else, those, I think, are our submissions.
Okay, let me check if there are any final questions. Ms. Mzwai?
No, thanks, Chair.
Professor Vilakazi?
Just one quick one, Chair, please. Mr. du Plessis, just to come back to the issue of assisting, kind of being a big part of the SABC's distribution of content, and I think he spoke about 20 to 30%. In the carrier agreement between, I think it's Platco and SABC, there's reference to signal distribution fee, right?
Yes, I think
am I correct? Yes, that's right, 7.4. Can I just check a factual issue, which is that, A, this is the fee that SABC pays to eMedia to carry those channels. Is that the correct understanding?
That's
to carry
how
the
I
SABC channels, right?
That's how I
so
understand.
there is a flow of funds from SABC to eMedia.
That's how
And then the second kind of factual question really is, does that fee, is there anything to say that that fee changes at all? If, for instance, something like the not OV, I've been calling it this in my head, the open view restriction comes into force, and for instance, the Rugby World Cup match doesn't get shown, and people get shown some other match. It doesn't change the standard fee, right?
Doesn't change the fee.
Okay, so your concern is not a commercial one. Your concern as it relates to SABC is not a commercial one for eMedia, in that you kind of effectively, as long as you're carrying SABC channels, will still get paid. It's that SABC is being denied the choice in terms of how it distributes the content that it has purchased.
Exactly.
Is that actually the crux of the thing?
Well,
so it's not an assisting thing, really. It's we get paid, but SABC is kind of not getting the choice that it should have in terms of how it distributes.
Well, it's that, yes, partly. You say it's the crux. I think the crux is perhaps slightly more, it's not perhaps quite as straightforward as that. What it is that certainly we are there and we have the carriage agreement and we are being paid to carry as eMedia. That is in the discharge, obviously, of the SABC's obligation. It has an obligation to do so as the national broadcaster under the ECA. It also has that duty, as we highlighted for you, under the Broadcasting Act. But in combination with that, it can't reach, and I just can't stress this enough, it can't reach what it says is 20 to 25%. I think at a point we might have thought it was 25 to 30%. But let's go with 20 to 25%. We're in the millions. It can't reach millions of its viewers because of the interposition of a clause by a party who has dominant power in this particular environment, and who says that we will not allow you to do your duty and discharge your statutory function without you promising to deny those viewers who have open view boxes from watching these sporting events. And that allows me then, I suppose, very quickly to say that it is therefore not just a case of us being concerned about that as eMedia. It's also about you as the tribunal having to be concerned about Multichoice's inhibition. It's inhibiting a state organ in the form of the SABC from fulfilling its duty by this imposition of a requirement and ultimately an interposition of itself between two contracting parties in the sub-licensing arrangement.
Understood. Thank you, Chair.
Thank you. Let me check if any of the council want to raise anything before we adjourn. Mr. Marriott, nothing further from you?
No, Chair. Thank you.
Okay. Mr. Trenga?
No, thank you, Chair.
Mr. Farlam?
No, I'm fine, thanks.
Okay, thanks. That then concludes the hearing. We'll give you our order with our reasons in due course, and we are adjourned. Thank you very much.